Lordship, may I be permitted
Today is not the mentioning day.
Huh.
Mention on Monday. Unless until it is extremely urgent, don't mention.
Urgent, my lord.
You cannot wait till Monday.
Yes, my lord.
Then mention on Monday.
The urgency is met by your lordship previous judgment and order dated 20th of August. I have been provided with a 2 weeks timeline to, in the case the impugned order goes against reason law. The reason order has been gone against me.
Recent order has been passed. Louder, please. Cannot hear you.
My lord, the reasoned order has gone against me, my lord, but I am protected by your lordship's previous judgment and order dated 28th of August.
What is the urgency, please?
My lord,
That you cannot wait on Monday to mention this matter.
I was seeking your lordship's leave to file and move because this
is not required.
my lord, 2 weeks.
Before this court, it comes under the as per presentation form.
That's right, my lord. But if,
Sorry, yes.
my lord, if it
Please call the list.
Item number 1.
May it please your lordship, beg to appear on behalf of the petitioner. Here,
Your lordship,
my lord, the petitioner happens to be a village police, my lord, who had joined in 2012. But I have the parent memo of the Home Police Department, which created, my lord,
Just a minute.
my lord. Yeah, doesn't work.
Presentation form has not been corrected.
Well, it has been.
No.
Lordship, দেখে বলছেন এখন হয়নি তাই বলুন।
Till it is group 9 matter. I cannot take up this matter.
My lord, may kindly grant us the liberty.
Issue.
আরে গ্রুপটা ঠিক করেছো কি? না দর্শক দেখে বলছেন যখন তাহলে গ্রুপ কি করছে? মানে
The pro forma page, it is corrected. In the presentation form, it is not corrected.
I lament the fact that I cannot act as an advocate.
On perusal of the
My lord,
presentation
grant me
form,
liberty, my lord, I'll do it right here.
on perusal of the presentation form, it appears that same has not been corrected to reclassify the writ petition as group 6 matter. Stop. Let the presentation form be corrected in terms of the leave granted by coordinate bench video order dated 28 November 2025 by 12th December
Well, do it
2025.
right here, right now.
Stop. List the matter under the heading. What is the urgency?
But the urgency is this, my lord, petitioner, 2012, he joined, my lord, as a village police. Village police, my lord, it states, my lord, there is a memo creating the post and stating, my lord, the procedure of recruitment process will be, my lord, in terms of the regular recruitment process. He has been continuing, my lord, without any complaint from any corner whatsoever.
What is the urgency? I
But
don't
his
find
father-
any correct answer or any specific answer rather.
I'll tell your lordship the urgency. His father happens to be a leader of the Bharatiya Janata Party. He was approached, my lord, mid-October to join the ruling faction. He declined, but since then, my lord, there is no communication, nothing, my lord. He is not being permitted, my lord, to work. So, my lord, there is a salary account where salary is regularly
From
credited.
which date he is not being permitted to
My
work?
lord, from 15th of October, my lord, he is not being permitted to join.
List the matter under the heading new motion on 16 December. There are so many matters. On 17 December 2020.
Very good. My lord, may I, my lord, just correct?
Yes, yes.
Right.
Item number 2.
for the response.
For the petition. Previously, your lordship, there is
Just a minute. Two more.
খবর হয়নি তো। ছজন হয়েছে শিওর না, এগুলো তো পেন্ডিং আছে। সাবমিট করবেন। 18
Yes. What about the revised list?
That, my lord, after passing this lord on the order on 13/5, lordship, my lord, the 9th/6 already, my lord, provided appointment, lordship, can you see the letter?
Yes.
So far as the CISF is concerned, my lord,
Where is the revised list?
my lord, kindly see the so far as the list of the,
I am asking you when the revised list was published. Where is the revised list?
kindly have a look, my lord, that
Answer the query. Where is the revised list?
kindly see this, it's differently, my lord, that was, my lord, kindly
Yes.
differently the candidates in the writ applications that has been indicated, my lord, out of 9, my lord, CISF concerned, my lord, I have already, my lord, given a lordship the steps taken, my lord, and so far as the, my lord, BSF is concerned, my lord, also, my lord, I have received.
I can't follow your submission.
My lord, understood, my lord, that so far as the revised list is
Where is
concerned,
Mr. Bajpai?
today is not here, my lord.
Yesterday matter was called on.
My lord,
He was not there. Where is Mr. Bajpai?
as far as
How long this will continue?
he is not well, my lord.
If he is not well, then make an alternative arrangement. Otherwise, I have to direct the additional Solicitor General to appear in this matter. Enough is enough.
Your lordship, kindly consider.
Yesterday matter was taken up. Nobody appeared. Matter was adjourned, and today you are making submission which is which this court cannot follow.
No, your lordship, kindly consider, my lord. Yesterday I was definitely worried, but one matter was taken by before Honorable Chief Justice, my lord. Therefore, I.
Is a fun going on before this court?
Mr. Bajpai yesterday he was not available, my lord. This is a difficulty today. Also, he is not well as I have received instruction.
Then
Lord,
make an alternative arrangement.
kindly keep it tomorrow, my lord. Tomorrow.
Tomorrow is the other matters are heard on Friday. Applications. Matters are not to be taken up according to your sweet will. Where is the revised list?
Lord, kindly keep it in mind.
Where is the revised
I'm
list?
trying to bring, my lord. We are taking steps.
Then who is to appear to apprise this court relating to revised list?
Lordship,
Let me
kindly-
direct the regional director to appear before this court personally.
Your lordship, kindly consider.
Yeah,
Kindly keep it on
no,
Monday,
no.
my lord. Your lordship, kindly keep it on Monday, my lord. Last
No.
chance, my lord. Maybe there is communication gap between Mr. Bajpai and department, maybe, my lord. Lordship, kindly as a last chance, keep it on Monday, my lord. Lordship, kindly keep it on Monday. This is my humble prayer before Lordship, my lord.
No, no, even do to Eastern Region Staff Selection Committee. Have you made staff selection committee party?
Yes, your lordship. He's there. It's already their party.
That I've seen.
Yes,
Where is the respondent? Regional director staff selection committee.
Yes, your lordship. Persona 2. Service to the regional director.
So let him appear tomorrow at 10:30
My lord, Lordship, kindly, my lord.
with the revised
Humble
list.
prepare before Lordship, my lord. Kindly as a last chance, your Lordship, kindly give us one chance, my lord. Your Lordship, kindly keep it on Monday, my lord.
What you are
My
making
prayer before
submission? Let me
Lordship,
see.
my lord.
What is your instruction?
My lord, my instructions so far as the letter that means, my lord, so far as the CIC is concerned, my lord, 9 candidates are there, my lord. My lord, already you are taking steps. To kindly see 6.
Just a minute.
It is intended that offer should to the following 6 co-petitioners. Stand amended by this office as per direction of the Honorable High Court. Arif Mia, Arif Mia,
So far as the BSC is.
Wait. Where is Moloy Bhattacharya ji?
Pawan Pawan, Barik. Commission of election including issue for seat of election. I am called Krishna to Sarkar Rahul Parishad.
So already six has been have been
Lord, these have
appointed.
also not been-
So far, my instruction, my lord, 6 has already been already given a letter of appointment, my lord.
Yes,
And so far, other
and three are awaiting.
3 are awaiting, my lord. Now the staff of the CISF, they are saying now at present that 3 has already given in the last day evening. They have already issued, my lord, letter of appointment.
Then what remains?
So far, the others,
Others, if they do not come within the zone of consideration, what can be done?
everybody's list has been, my lord.
Why others are left out?
Lord, similar.
Others has been placed before the SSC for revised, my lord. All are eligible, my lord.
Milord, we are taking steps, Milord. Actually, they need appointment, Milord. We are taking steps, Milord. We are not deserving this lordship's order, Milord. We have no intention, Milord. Maybe there are some difficulties, Milord, that are taking a few times, Milord, to comply with lordship's order, Milord.
ওদের রিপোর্টটা আগে দিন আমাদের কাছে না ওদের রিপোর্টটা
No, now how many petitioners are there?
18
18. Out of 18, 6 have already been appointed. 3 are also will be appointed.
also
3 are also 3 have also been appointed. So 9 out of 18 have been appointed. Now so far Sumon Saha order of appointment to join BSF has already been issued. Then Sujit Bhadro appointment has already been issued. Mujibar Rahman same appointment letter, appointment order of appointment issued. Parijat Rai under investigation with CFPB New Delhi, and result so far Arup Nath revision result is yet to be received. So the steps have been taken.
9 plus 4 13 has been given so far today's instructions, my lord. Last occasion on behalf of the, my lord, Union of India, they have said they have cleared all the CFSL and all these things. They have placed their result before the, my lord, SSC for revision.
So matter is taken up for consideration when copy of a letter dated 8 December 2025 and a chart signed by commandant within bracket establishment ESTT close bracket for IGFTR দেখে নেবে ভালো করে ভুলভাল করবে না HQR BSF SB এই যে
এটা দিয়ে আজকে মোটে রিপোর্ট একটা
কি বললাম and পরে so and so on 8 December 2025 are placed before this court and taken on record. Stop. Next paragraph, relying upon aforesaid two documents, it is submitted on behalf of respondent authorities that out of 18 petitioners, 6 petitioners have already been given appointment and 3 are awaiting for appointment letter. Stop. Next paragraph. On query being posed to the learned advocate representing the respondent authorities that still nine candidates are left. comma, it is submitted, it is replied that steps are being taken to consider the candidature of those 9 candidates for being appointed if they are found eligible. Next paragraph. To grant the concerned respondent authorities opportunity to take steps relating to appointment of rest of 9 candidates. Hearing of this matter stands adjourned. Establish the matter under the same heading for further consideration on 8 January 2026. Next.
Item number 3.
May I plead the lordship, I am for the petition.
Yes.
For the respondent, my lord, my X-ray is not done. The experienced doctor found it is not required. A report submitted, my lord.
Where is Mr. Otharup Banerjee?
Para 2,
Where is Mr. Otharup Banerjee?
he is ill in the hospital, my lord.
What has happened to him?
Yes, something, he told me that I am in the hospital. You do.
But where is the extrapolate?
Except it is not done, my lord.
Why it was not done?
Yes,
Why it was not done?
not
As
done.
per guidelines, court said that extrapolate is required.
But the department has informed the experienced doctor.
So
found no
without
requirement.
extrapolate, how knock-knee was diagnosed?
Submitted report that X-ray is not required. That is why not done, my lord. Report submitted, my lord. Page 2, para 4. Page 2, para 4, my lord.
which clause you are relying upon for
Clause
that
7.
X-ray is required to be
Clause
performed
7.
to find out knock-knee or
Well,
intermalleolar distance?
Yes, my lord. I have hand over the earlier occasion. The guideline is there.
Yes, yes, it is there.
My lord, clause 7 of review medical examination guideline. Clause 7. I, small I. I think your lordship is plucked it. Should be. What is should be?
No, it starts with the sentence, clause 7.
Yes.
Following examples are cited for the guidance of the review medical.
Review medical.
It is for guidance.
It is for the
It's not an obligatory on the part
Yes,
of the
there-
review medical book.
there is a
And it is said that for knock-knee, bow leg, cubis, and so deformity and other deformities, X-ray plate with findings should be attached.
should be attached.
Now they are in the report they have disclosed that in the petitioner's case, review medical examination board clinically measured the intermalleolar distance as 7 centimeter, which is above the permissible limit of 5 centimeter. Clinical measurement is the primary and standard method of assessing knock-knee. X-ray is required only in doubtful and ambiguous cases.
Yes, here my
As per Border Security Force Manual, Volume 10, Volume 9, Medical Directorate, 4th edition, Part 2, Chapter 4, Ministry of Home Affairs, Police Division 2, revised guideline as on May 2015, page 355, paragraph note C. In doubtful cases, candidates may be referred to a specialist for examination and opinion, which may include X-ray.
well, that guideline, whichever my learned friend hand over to just now your lordship, that is applicable for
355, just a minute.
there is no such page at all. Well, that is for the recruited employee, those who are in service. That is not for the
No, that's why in some of the cases, court also finds that at the instance of BSF, it is being sent to several several
Yes,
hospitals.
that's why page 28.
In doubt, since those are the cases, those are doubtful cases.
Yes, there
But
is.
here they are saying, because court is not medical expert,
Yes, that's
they are saying that in petitioner's case, the review medical examination board clinically measured that it is not, they are saying that it's not a doubtful case.
Well, kindly have a look, page 28 of my writ application, first 27. 27 of my writ application.
Where is this provision? As it is referred to under paragraph 6, that is Border Security Force Manual Volume 10, Medical Directorate, 4th edition, Part 2, Chapter 4, Ministry of Home Affairs.
That
Where
is-
is such provision? Show me that provision.
That is for
And it's a mere guidance.
that
It
is
says, clause 7 says it's a mere guidance.
that is for the purpose, as your lordship just now fallen for your lordship, that is for the purpose of the assessment of the.
Do you have such provision
BSF,
to place it
not
before place it before this court?
My lord, kindly my lord, kindly have a look on the clause 8 also, the following.
You don't have.
Kindly have a look on the clause 8 prior to consider that.
In terms of the previous order, dated 24th November 2025. A report is filed, a report signed by officiating Deputy Inspector General SHQ BSF Kuchbihar. And same is taken on record. Stop. It is disclosed in the report that petitioner was examined that is detailed medical examination within bracket DME on 8 October 2024 at 41 BN Battalion BN SSB Ranidanga, district Darjeeling, within bracket West Bengal, where he was declared medically unfit on the following grounds: colon dash, knock knee পেয়ে যাবে এখানে এই যে বোল্ড করা আছে দেখুন, knock knee distance 5 centimeter, 2 Roman 2 carrying angle is a right 21 degree, left 23 degree. 3 left testicular enlargement. Stop. Next paragraph. It is also clarified in the report that Review Medical Examination Board clinically measured intermalleolar distance. দেখে নেবে এখান যাওয়া intermalleolar distance as 7 centimeter, which is above the permissible limit, that is 5 centimeter. Stop. Clinical measurement is the primary and standard method of assessing knock knee. Stop. X-ray is required only in doubtful or ambiguous cases. Stop. In this regard, stop. On behalf of the petitioner, placing reliance on revised uniform guidelines for review medical examination in Central Armed Police Forces and Assam Rifles. It is contended that for knock knee in support of that for knock knee, X-ray plate needs to be assessed in order to come to a definite finding. Stop. However, on perusal of clause 7
Clause 8 also. Your lordship says.
of the revised guidelines of May 2015, however, it is found that certain examples are provided for guidance of review medical board. Stop. Review medical board, and under 7I within bracket I small I, it is provided for knock-knee, comma bow leg এখানে পাবে cubitus valgus and varus deformities, comma. It should be and X-ray plate deformities. X-ray plate with findings should be attached. Next paragraph. Therefore, clause 7 of the revised guidelines by giving certain examples gave or offered guidance as to how review medical board should exercise as to how review medical board RMB as to how review medical board should examine the candidates to derive finding relating to physical condition of the petitioner, relating to physical condition, relating to their physical condition. Stop. Next paragraph. In the report filed today, it is clarified that review medical board clinically measured intermalleolar distance as 7 centimeter, which is above permissible limit of 5 centimeter.
DME also in DME 5 centimeter as they has found.
Sentence ever পড়ো। That it is a case of intermalleolar distance which was primarily found as 7 centimeter, but in review medical examination it was found which was primarily found and in review medical examination it was detected 5 centimeter. But apart from this deformity, review medical board
Page 27, man. Thank you.
Reported it was a case of carrying angle left 21 degree and right 23 degree. And furthermore, petitioner was diagnosed with testicular enlargement. Stop. Stop.
Well, the petitioner was never diagnosed with the testicular method. That is also my case. Well, USG has not been done.
Stop. Therefore, the reason for declaring the petitioner medical next paragraph. Therefore, reason for declaring the petitioner medically unfit is not only confined to knock-knee, but there are aforesaid, but there are other reasons as aforesaid. But there are two other reasons as aforesaid. Next paragraph. Next paragraph. In addition, there are two. On perusal of clause 7, within bracket small I of the revised guidelines of May 2015 does not prescribe does not prescribe X-ray plate to be provided in all cases relating to knock-knee. As mandatory requirement. Rather, it is a guidance. Next paragraph. When petitioner was clinically measured by the review medical board that intermalleolar distance as 7 centimeter, it is a case of intermalleolar distance of 7 centimeter. দরকার নেই, কেটে দাও। কি বলছেন? আচ্ছা, না দরকার নেই, ওটা সেন্টেন্সটা কেটে দাও। In the report, it is disclosed that X-ray is required in case of intermalleolar distance and knock-knee in doubtful and ambiguous cases. This court is not inclined to interfere with the finding of the review medical board. Stop. Next paragraph. Hence, no relief is granted to the petitioner. Writ petition stands dismissed.
That petitioner kindly consider page 26(1)
Next matter.
and 28. But another ground also assigned.
Judgment from hearing concluded, judgment from. Next.
Item number 4.
They appear for the petitioner.
Which is filed under
My lord, on the previous occasion, my lord had directed
like this. That's optional.
Yes, yes.
Yes, my lord had directed to find out whether he had been confirmed in his post or not. My lord, there has been a letter sent to him, my lord, on the 28th of June 2025. My lord, as of my lord, today then, my lord, the writ petition, my lord, does not have any grounds and can be otherwise disposed of, my lord.
Does not have any.
My lord, does not remain in fruition, my lord. This becomes infructuous to an extent. My lord, only one prayer that is to be made, my lord, is that, my lord, his letter, my lord, sent to him by way of this office order of 27th of February 2023 that said that he was fit to be confirmed,
He was.
fit to be confirmed in his post, my lord, without any back wages, my lord. My lord, his confirmation only came, my lord, after 2 years of that. My lord, if arrears could be given for that period at least, my lord. My lord, I am otherwise going to be able to withdraw this.
It's a contradictory submissions you are making. In one hand, you are saying it has become infructuous.
Sir,
In other hand, you are praying for direction to release ADR salary. Choice is yours. Court will not try to impose anything upon the petitioner.
No.
How you will place your case, choice is yours. Both things cannot run together.
My lord.
Both submissions cannot go together.
My lord, as of 2025, my lord, he
Are
has.
you submitting that the writ petition should be dismissed on the ground since it is infructuous, or you want to press the prayer for release of ADSR?
My lord, only for that period, my lord. Between 2020.
Then it is not infructuous.
No, my no, my lord. Since, my lord, if I may just show one part of the order of justice.
What you have prayed for? Let me see.
Yes. Only for. The prayers, my lord, would find at page 7, my lord.
So you have prayed for confirmation that has been confirmed.
My lord,
So what remains? You have not prayed for any ADS salary.
my lord, no.
In the writ petition, there is no such prayer.
My lord, that would possibly be within the consequential.
In the writ petition, there is no such prayer.
No, my.
So then,
My lord, I am not praying for any.
when petitioner has been confirmed?
My lord, 2025, my lord, in June. The writ petition was from January 2020.
Yes. So it has become infructuous.
Yes.
Esho.
My lord, if one thing I.
No, nothing can be done. It is not in the prayer. It is submitted on behalf of the petitioner that the service of the petitioner was confirmed after filing of this writ petition. Stop. Next paragraph. In view of after filing of this writ petition. Stop. However, it is submitted that petitioner is entitled to get arrears salary. Stop. Respondents are represented by learned advocates. Next paragraph. In view of the submission, in view of submission made on behalf of the petitioner, it appears that primary grievance of the petitioner stands redressed. Stop. Writ petition stands disposed of. However, this order shall not. However, petitioner shall be at liberty to make a prayer. To make a representation before the concerned respondent authority seeking release of arrear dues. Stop. If such representation is made, court expects same shall be decided in accordance with law by the concerned authority. Stop. Urgent Xerox certificate.
Item number 5.
My lord,
My lord, before my
Petitioner,
lord,
my lord.
before my lord starts with the matter, my lord, one Marina Khatun has been made party as a private respondent in the matter. My lord, his husband came today without the brief and without the Vokalatnama. My lord, I am praying for at least short time.
Who has been made party?
Marina Khatun, as I have been informed by his husband.
Respondent 8, Lordship. Private.
And what about 9?
I don't know, my lord.
Masuba Bibi?
My lord, I don't have the copy of the brief yet. My lord, I can canvass your lordship.
On behalf of respondent number 8, accommodation is paid for to obtain instructions. Stop. However, petitioner and state respondents are represented by learned advocates. Stop. Acceding, next paragraph. Acceding to the prayer made on behalf of respondent number 8, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 23rd December 2020. Next.
Item number 6.
This may I please first spam for the petitioner. My lord, I am filing the supplementary evidence, my lord, and inadvertently has been missed the time of filing the writ application, and I have paid the deficient court fees also. My lord, here the payer is the my lord, the petitioners had rejected on the grounds of shortfall of height. My lord, they preferred appeal subsequently thereafter through email, but
That is in connection with previous election process.
2025.
Yes.
2025.
25. Yes.
My lord, they have been their candidature has been rejected on the ground of shortfall of height. They wished to prefer the appeal on the same date, but they could not. Subsequently, thereafter, through email, they have filed their respective appeals to the authority concerned, but till date, that appeal has not been considered for remeasurement.
So no prayer for review. Review measurement, there was no
Yes,
prayer.
there is a prayer for remeasurement.
Remeasurement.
Yes, my lord.
So, but in all cases, remeasurement is done.
Some cases done, some cases your lordship now direction has been passed, they are going to, my lord, remeasure the,
Who is to remeasure?
my lord, now the board has, my lord,
Dissolved.
respondent number 5. Respondent, your lordship may give a direction to the respondent number 5. They can, my lord, he can constitute the board. He can constitute the board for remeasure.
No. In other cases, I did not direct to constitute board.
My lord,
I directed the authority to make measurement and within a certain time, and result of measurement should be forwarded to the disclosed to the petitioners.
my lord,
So therefore, there was no direction for formation of board at this stage, at the belated stage.
in that event, 7 is the Inspector General CRPF. My lord. Sorry.
Whether let it be remeasured.
My lord, the supplementary affidavit, appeal has been added.
Appeal?
Inadvertently, it has been not added to the petition. My lord, that's my earlier.
Preferred appeal.
Prior to filing this return.
In all the 4 cases, petitioners were height of the petitioner was was found to be less than 170 centimeter.
170 centimeter and less than also 169.5.
My lord, one indulgence, my lord. Here the candidates whose initial PhD has been done by some cases SSB, some cases my lord CRPF. So my lord, if your lordship direct that concerned authority, my lord.
No. Let the Inspector General Central Reserve Force do this.
A nodal agency is
Yes.
just here.
Supplementary affidavit filed on behalf of the petitioner is taken on record. Next paragraph. Petitioners participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within bracket CAPFS. Stop. In physical measurement test within bracket PST, close bracket, height of the petitioners were assessed less than requisite height, that is 170 centimeter. Stop. Petitioners preferred appeal before the concerned authority, but the grievance of the petitioner is those appeals are yet to be decided. Next paragraph. Respondents are represented by learned advocate who has submitted that the board which was constituted to decide the appeal is no more in existence. Stop. It is also submitted that concerned respondent authorities may be directed to decide the appeal. Next paragraph. From the submission made on behalf of parties, it appears that the board constituted for the selection process is not in existence, and the appeals preferred by the petitioners, questioning measurement of their height is or is to are till date not disposed of. Next stop. Next paragraph. Hence, Inspector General Central Reserve Police Force, headquarters, Kolkata, being respondent number 7, is directed to decide the appeals of the petitioners relating to height by 4 weeks from the date of communication of this order, and the result and the decision to be communicated to the petitioners by 7 days thereafter. Next paragraph. Writ petition stands disposed of urgently.
In the event they have come within the zone of consideration.
Writ petition stands disposed of. Next paragraph. However, it is clarified that in the event petitioner's height, petitioner's plural apostrophe, petitioner's height was found to be within the prescribed limit, consequential steps shall be taken for consideration of candidature of the petitioners for being appointed against the post of Constable GD under CAPFS. Next.
Item number 7.
Lordship, on for the petitioner. Lordship, the petitioner retired in the year of 2001, 30th March 2001. Last occasion, your Lordship want to know in which date, specifically mention the date. In 30th March 2001, the petitioner retired from his service in GSH scheme. Golden Shekhar.
DRS.
Golden Shekhar scheme. So, Lordship, he received his gratuity, but till date, the CMPF accumulation and pension is pending.
Pension and
CMPF accumulation,
provident fund dues.
till date.
Yes.
My lord, pension and
When you have retired on voluntary, it is a case of voluntary retirement.
Yes, Lordship. Yes,
When you
Lordship.
retired?
Yes, Lordship. GSH scheme means voluntary retirement. The year of 55 years, he
It
wants.
is VSH scheme.
The GSH.
GSH.
Golden Shekhar scheme. Lordship, there is a dispute regarding.
So when the service of the petitioner came to an end,
It's a.
applying this scheme, GSH scheme,
It's 2001.
Date.
30th March 2001.
31st of March.
30th.
30 March 2000.
2001.
So why you are coming after such a long time?
Lordship, I'm coming to that point.
After 24 years?
Yes, Lordship. I made several representation to the authorities.
For 24 years you are making representation.
Yes, Lordship.
Making one after another representation does not save the period of limitation.
Yes, Lordship. Please come to the come to my
Who?
come to annexure P2.
Who will believe it that your provident fund is not paid? It is your money. On the next date, petitioner comes to the court.
Yes, Lordship.
So, and you are you took
Lordship,
retirement under GSH scheme on
Lordship.
30th March 2001, and today you are coming.
Lordship, there is a dispute regarding the father's name of the petitioner. So that's why from the ECL authority they made a police verification also. Police verification report come, but after that also, after police verification report come in the year of 2018. After that, the petitioner went to the office of the.
So even if after 2018 it is 7 years.
Yes, Lordship. Several times, but verbally they are telling, yes, we are working. Account number dispute regarding the account number and the father's name. So because of that, this process is being delayed. Can understand, but it's verbally several times we informed they.
Court will not grant any interest because delay is not attributable wholly to the authority.
Lordship,
Court will not grant any interest. If you want to do the matter, please do this matter. Please don't disturb her. This is not the way to address the court. If you want to do the matter, come at the front and do the place the matter. What is this? Yes,
Lordship, kindly come to page 23. Lordship, kindly come. Annexure P6. This is the police verification report.
yes.
His Lordship. This is the police verification report. I see.
By Odisha police? Petitioner was working where?
She was working in Bansra, initially in Bansra OC wagon loader, as wagon loader having human number 427495.
In which colliery?
Bansra Korean, initially on Bansra Korean.
Where it is?
In
Where-
the year of 19.
Where it is?
It is
In Odisha?
No, it is in
Bardhaman.
Bardhaman district, Paschim Bardhaman.
Paschim Bardhaman.
এটা নেই তো? এটা এটা আছে। হ্যাঁ, এটা আছে। এটা আছে। না,
Have you made such colliery party?
Yes.
Which respondent?
That colliery is under Eastern Coalfields. Respondent number 22.
How you have added colliery? Which respondent?
Lordship.
Petitioner retired from which, retired on 30th of March from which colliery? And where is the respondent?
Area personal manager, Kunustoria area.
Respondent number?
It's respondent number, Kunustoria area.
6.
5, the general manager, Kunustoria area. 6 also the area personal manager, Kunustoria area.
Yes, when you have forwarded the claim to the Provident Fund organization regarding Provident Fund and pension,
My lord,
only gratuity is paid.
Yes, Lordship.
Yes, just a minute. First, claim is to be forwarded by the Coal India Limited or Eastern Coalfields to the Provident Fund organization, and then you will release it. Just a minute.
my lord, in 2016, before 2016, it was sent to them
When?
by a letter dated 22/1/2016. The Provident Fund Authority has informed that I can give the communication made by the Provident
So
Fund.
why 22nd January 2016 this claim was forwarded?
Regarding
Petitioner retired on 30th of
regarding
March.
payment, they have commented. Some dispute is there. I'm coming to that point, my lord.
We have received the claim actually on 10/9/2014. 10/9/2014. That is in production of Goda, son of Grish Goda, sealed to cap number 2/219/B/. But that claim was written as the sealed account number given by them that 2/219/B/20 was already to one Chinap Oxford, not Chinap Goda, who retired on PRS from Mandarapuri Colliery. And Provident Fund amount has already been paid to him on 29/2/2008. Way back on 29 February 2008, it has been paid to one Mr. Chinap Oxford. Then several correspondence have
In connection with service of the father of the petitioner, as it is alleged in this writ petition. Who was name of the employee? Name of the employee?
Dinath Goda, son of Yudhishthira Goda. He is the claimant and father name is correct. But what my friend is referring, that payment has been made
Here
to
the employee
different
has come
person.
with this writ petition.
Yes.
Oh. So the employee is before this court. It is not the legal heir of the employee. So Trinath Gowda himself has come alleging that the payment has not been made to him. Show
Yes.
me that he has been paid provident fund dues and pension. Matter ends.
He has been paid to one Srinath Patro. Then what happened?
No, this court is not concerned with Srinath Patro. Court is considering the claim of the petitioner Srinath Gowda.
Srinath Gowda, but account number is also it's vital. Account number allotted against Srinath Gowda, that account number is given. Account number was otherwise correct.
Lordship, come to the ID card. Come to the ID card.
ID card 280.
Yes, Lordship. That is the number.
280.
Now we have
Page number 17, Lordship.
the matter with
ID card is annexed at page 17. It is stated Srinath Gowda, Judishati Gowda.
Membership number is 280, my lord. And in that
Membership
account, we
number,
have,
where it is membership number in the ID card?
in the said account, we have deposited the
No,
entire
the
money.
name of the employee is Srinath Gowda, who is the petitioner. Show me that Srinath Gowda is paid. This is the ID card, page 17.
Now there are what happened?
Lordship, they are confusing. They have it's account number.
Now,
My lord, the ECL authority has deposited the money with the Provident Fund Authority, Coal Mines Provident Fund Authority, under in the name of the petitioner, under membership number 280.
so is it there, whether it is there in
giving the
the
statement.
membership number is there in page 17?
Yes, 280. Same number we have deposited. 280. Serial number 40, my lord.
This petitioner yet not received. Lordship.
Why you have cleared the page and given?
Patro ke pura.
This is the part too.
Oh,
This was the part. Don't give like this.
we have
Name of the Siddharth Patro. He's been
retirement, we deposited the money in that account and they have received. And 2015,
Yes, please come to page 17. Now, this is the ID card. Please hear this quote. This is the ID card. Number is 2/219 capital B /280. Now, a statement is placed before this court on behalf of Eastern Coalfields that Srinath Gowda, father's name Judishati Gowda, and the number is telling that is 2/219 capital B /280. And then amount of 4,27,495. That is the amount which was paid. Or it is, what is this? The last but one column,
Last one.
Mm.
What you have submitted.
extreme right.
yeah,
You're right.
yes,
Just before PTR,
That's before
unique.
the unique man number. এটা আমরা সাবমিট করেছি ইউনিক
What is this?
what is this unique man number the court is asking
I have no idea. I have no idea, my lord.
So therefore claim was forwarded. If you have made a payment to a different person, for that right
No,
of the
different-
petitioner to go get the benefit does not obliterate. So therefore either you have to show that this payment was made to Srinath Gowda, or court has to give direction for release of those benefits in favor of the petitioner.
We have made the payment to that account number.
Where is the account number in the identity card?
The number 2/219 capital B /28.
Yes.
We have made the payment. This number is.
That is CMPF number,
CPF account, right?
Coal Mines Provident Fund account number. Yes,
We have received the claim on 10/9/2014.
very well file a report. Very well file a report showing the payment. Yes, yes. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. It is submitted that petitioner took retirement under GHS scheme on 30th March 2001. Stop. Petitioner was working in a colliery under
1 minute, 1 minute. I'm giving.
Eastern Coalfields Limited. Stop. It is further submitted that though petitioner retired on 30th March 2001, till date Provident Fund dues and pension have not been released in his favor. Next paragraph. On behalf of Eastern Coalfields Limited, it is submitted that claim was forwarded to Coal Mines Provident Fund Organization, to the concerned authority of Coal Mines Provident Fund Organization, being respondent number 8 and 9. Stop. Next paragraph. Mr. Kollol Gotakurata, learned advocate representing Coal Mines Provident Fund Organization, has submitted that payment was made towards Provident Fund dues. Pension is to be paid by whom? Provident Fund dues and pension to the account of the petitioner as stated in his identity card, which is at page 17 of the writ petition, comma, according to CMPF authority, account number of the petitioner was 2/219-B/280. Stop. Next paragraph. In view of submission made on behalf of CMPF authority, concerned authority of authority of CMPF is directed to file a report in the form of affidavit disclosing payment made to the petitioner towards Provident Fund and pension with necessary particulars. Stop. Let such report, next paragraph, let such report be filed by fortnight from date. Stop. List the matter under the same heading for further consideration on 13th January 2026. 1-3.
Lordship, I want to draw your attention to the
Next matter. Sorry.
Item number 8. I am for the respondent, my lord.
Yeah,
Yes, what is your instruction?
My lord, if your lordship kindly come page number 30 of 35 of the writ petition, my lord.
Yes.
He qualified in the, as per my lord, that relaxation 169.5 in the height, my lord. 2D relaxation. Now, with regarding to the my lord chest, minimum expansion is required, my lord, 5 centimeter. If your lordship
Normal chest centimeter 80.
minimum 80,
Required 80, whereas petitioner, it
Obtain
was
80.
measured for, so far petitioner is concerned 85.
no, 80 and 83, and expanded chest 85 minimum required. He obtained, my lord, 88. Now the if your lord-
83.1 and 88.
88. Now, my lord, if your lordship kindly see, chest expansion minimum required, my lord, 5 centimeter. He is below 5 centimeter, 4.9, my lord. This is the
So the gap in between normal chest position and expanded position should be 5 centimeters.
whatever
That is lacking so far petitioner is concerned.
if, my lord, his chest minimum
That is
chest,
why 80 and 85.
grateful, my lord. 80.
Difference is 5 centimeters.
Absolutely, my lord.
So in expanded position, it should be higher by at least by 5 centimeters.
Grateful, my lord. This is the, my lord, may submit.
0.1
This is the guidelines, if your lordship kindly see.
83.
F, my lord. Point number F. দাঁড়াও বলছি।
Just 0.1 centimeter less.
Yes.
0.1 centimeter. That's why I'm paying for, kindly, give a direction to write down.
F, my lord.
As
My lord, rounding is not applicable in chest,
in
my lord.
height
This is a
case,
guidelines.
Cannot exercise discretion in this matter unless there is a provision. Court is contemplating whether this, or court is finding if the benefit of relaxation as contemplated under clause 2D can be extended in case of height.
Okay.
But in chest, if there is no provision, nothing can be done.
What humbly pay before you lost his
F 5.5, my
0.1
F, my lord. F.
centimeter for
Where it is provided 5 centimeter.
My lord,
Just,
kindly.
F.
F.
Just a minute. This is suitable well for just. This should expand. Just 5 centimeter.
F, তোমার লাগানো নেই এটা।
Please,
গাইডলাইন্সটা দাও না, আমি বলে দিচ্ছি। ওইটা দেন, জেনারেল গাইডলাইন্স।
Issue.
Grateful, my lord.
Matter is heard in presence of the learned advocates representing the petitioner and Union of India. Stop. Next paragraph. Petitioner participated in the selection test for being appointed as Constable GD under Central Armed Police Forces within bracket CAPFS. Stop. আজকে কি রণজিৎ আসেনি? রণজিৎ এসছে? রণজিৎ কোথায়? It is review test.
Yes.
it is reviewed in the review after getting the appeal.
It is contended, next paragraph, it is contended on behalf of the petitioner that in review physical standard test, chest of the petitioner in normal position was measured 83.1 centimeter, and in expanded position it was measured 88 centimeter or 88.0 centimeter. Stop. According to the petitioner, length of chest in normal position as per norms has to be 80 centimeter or above, and in expanded position such length has to be 85 centimeter and above. Stop. In both the situations, chest of the petitioner was measured above requisite length. As a result, pair of petitioner ought to have been declared physically fit, or ought to have been declared eligible for being considered for the post of Constable GD. Next paragraph. Learned advocate representing Union of India has opposed this writ petition, and reliance is placed on clause 5 within bracket F of revised guidelines of May 2015. Stop. Under clause 5, within bracket small f, it is provided while examining the candidates principal points which need careful attention are সেন্টেন্সটা মানে ক্লজ 5 এ হবে না। Clause 5. Clause 5 of under clause 5, while কেটে দাও। At the time of examining candidates, principal points are indicated under several subclauses, amongst which under subclause within bracket small f, it is provided chest should expand for at least 5 centimeter with ease. Stop. Based on such provision, it is submitted that there has to be difference of at least 5 centimeter in length of chest in normal and expanded position. Next paragraph. Having considered the submissions made on behalf of the parties, this court finds substance in the submission made on behalf of respondent authorities. Since it is specifically provided under clause 5 within bracket F of the revised guidelines dated May 2015. Revised guidelines of May 2015, that chest should expand for at least 5 centimeter with ease, meaning thereby there has to be difference of 5 centimeter in length of chest while in length of chest in length of chest during normal and expanded position. Next paragraph. In the present case, in normal position, length of the chest was measured 83.1 centimeter, whereas in expanded position it was measured 88.0 centimeter. Therefore, there is difference of 0.1 centimeter therefore requisite difference of 5 centimeter is not maintained. Therefore, requisite difference of 5 centimeter is not maintained. Stop. Next paragraph. Hence, this court finds no anomaly in deciding that petitioner is not eligible to be considered for appointment in the post of Constable GD under CAPFS based on review physical measurement. Stop. Writ petition stands dismissed.
My lord, one intelligence, my lord. If your lordship, I am also relying upon that guidelines. If your lordship, page number 38 of the writ petition. Page 38, my lord. No, the writ petition, my lord, writ petition. Only writ petition, page 38. 12.5.2, their minimum expense, my lord, 12.5.2.2. I am also relying this, my lord.
Yes.
I'll only indicate, my lord, kindly, my lord.
Next বাচ্চা applies. হ্যাঁ,
Guidelines.
Item number 9. In this matter, my lord. Here, my lord, I am praying for, my lord, stay of the disciplinary proceedings during pendency of the, my lord, criminal proceedings, my lord. Lord, please kindly come page 33. This is the memo issued by, my lord, the chairman cum managing director of Eastern Coalfield. Now, relevant part is, my lord, page 34. Your lordship will find
what is page 33?
33 is starting, my lord. Memo has been started, my lord. Starting
What is this?
charge sheet, my lord. Charge sheet, my lord.
Say so.
My lord. Charge sheet. Page 33 is charge sheet. 34 is the statement of articles of the charges, my lord.
Yes.
Based on the complaint dated such and such of MD Salim, son of late such and such, working as General Mojdur, Sampur B colliery of such and such area, alleging demand of bribe by one Sri Praveen Kumar Mishra, such and such, manager B colliery of Mogma area, Eastern Coalfield Limited, of rupees 50,000, to retain MD Salim at the same place of posting, that is magazine explosive room of such and such colliery at ECL Dhanbad. An investigation was carried out by CBI ACB Dhanbad on such and such. It has been revealed during the investigation of the CBI ACB Dhanbad that Sri Praveen Kumar Mishra, in connivance with other officials of Sampur Mugma area ECL, allegedly committed gross irregularities by demanding and accepting illegal gratification of such and such. So, my lord, based on, my lord, the CBI complaint and charge sheet,
Committed gross irregularities.
But the same issue, it is in Dhanbad.
no, the charge sheet has been issued from West Bengal.
Sampur B coal area, ECL Dhanbad.
Yes, charge sheet has been issued from here. I mean, the officer of the Coal India
Yes, but where the inquiry is being conducted?
at Asansol.
At Asansol.
Yes. If you'll also kindly come page 33 at bottom.
And that is the nature of charge in the charge sheet
Same.
relating to criminal proceeding.
My lord. Before that, well, if you'll also kindly come page 33, my lord, once, my lord.
When where the inquiry, when the next date of inquiry is fixed?
Today, my lord.
Today.
My lord. Now, my lord, if you'll also kindly come page 33 at bottom, you'll also will find the address.
Page 33 bottom.
33 bottom, my lord.
Yes.
Chaktoria Post, Disargod District, Paschim Bardhaman, West Bengal.
Charge sheet was issued.
Charge sheet. Charge sheet was issued from West Bengal, and inquiry is also being conducted at, my lord, Asansol, my lord.
So this is territorial jurisdiction is not an issue.
No.
Then if at this stage, if defense is disclosed,
I have only one point to say, my lord.
Because in two other matters, I have passed orders.
I have the
One
order.
of the matters, two other matters, my lord, I was there.
And only one thing, my lord, may I, my lord, clarify? There are two persons involved in this, my lord, proceedings. One has approached earlier, my lord, got stay.
Well, that may be, my lord.
From a coordinate bench.
Yes, earlier bench, my lord.
Here, my lord,
I have the order, my lord.
here, my lord, I have only one thing to say. I will not take your lordship's much time. Lordship is correct, my lord.
Well, who is the other person?
Other person's name is, my lord, Gaur Ramani, my lord.
But his name is not there in this
No,
in
but
this chart.
his name is here, my lord. I will, in the charge sheet, your lord.
Both are implicated in the same criminal
Same.
I think Gaur Ramani must Gaur Ramani, you have got the stay.
Yes,
Justice.
yes.
No, it was hard out. There was a temporary
no,
stay, but it was hard of the this Mugma area. So
Yes, here, my lord,
no, I think Gaur Ramani was non-executive. I do not
not
know.
executive, but he got the stay.
But from Mugma it was issued because that matter, my lord, I know because I was also, my lord, hearing another matter was going on. I do not know. Stay means the preliminary one. Whether ultimately the stay was continuing till date or the hearing was there, which
still
was
it
under
continue.
4 orders. Order was reserved by the coordinate bench. I
Till
don't
date it is
so
continuing.
whatever it is, it's not concerned, my lord. Here, my lord, I will say only one thing, my lord. Apart from saying, my lord, I am not going into all the whether the charges are different or not. According to me, the charges are there are additional in the other matters. Two other matters your lordship decided. Your lordship said main charge is bribery. Whether you have the other charges or not, those are ancillary. Your lordship please to hold that. Now here, my lord, I will only say that he has already the ground is that his defense will be disclosed. Now, my lord, I will show only two documents. My lord, he has already disclosed his defense.
Well, wait, I'm coming there.
Very well, my lord.
But if your lordship kindly compare, my lord, the list of
My lord,
witnesses.
he has finished already. I was, and it's, let him do it. Let him.
Yes, yes, yes.
Well, the only thing is I am not going to the other factors because on the last occasion, your lordship mainly based the impol Antony's case and passed that order.
Yes.
On the last occasion, my lord, these two orders, my lord, lordship based on, lordship passed that order based on the impol, basically on the impol Antony's case, my lord. I am not going to distinguish all these things. Only thing is, my lord, because the reasoning is that his defense will be disclosed. That's the reasoning. Here, my lord, if your lordship takes up, my lord, I will show, my lord, only 2 pages or 3 pages, my lord. If your lordship comes to page 116, this is because it's from April 2025, it's going on, my lord, and he has participated, my lord. Now, my lord,
From April 2021,
25,
25.
25, my lord, it's going
So
on.
this inquiry is going on.
It's going on, my lord. Now he has what he has submitted.
So what is the present stage of inquiry?
It's going and my lord, it's witness witness action.
Is going on.
Is witness action, my lord. Well, kindly see, this is of 30th 10 minutes of the 30th October 2025, page 116. Page 116, my lord. I will take your request your lordship to come to next page 117, my lord. Start, my lord, list of management witnesses. Thereafter, my lord, PO stated
117.
117.
Yes.
The continuation of that. PO stated that additional witness, if any, arising out of in course of proceedings may be presented. IA stated that same request to be justified as and when the situation arises. Now, my lord, CO means the charged officer submitted the following defense documents for his defense. So he has disclosed his defense documents.
IA, who is IA?
IA is the presenting officer.
No, PO is the
The
present.
PO is the presenting officer. The IA stated that some same request, my lord. My lord, it's
Who is IA?
IA, my lord. I have forgotten, my lord. He's also an officer. Who is,
And CO submitted.
CA is the charged officer. Charged
Yes,
officer.
that is known to us. EO, PO.
No,
CO,
IA,
but
my
who
lord.
is
I
IA?
have recorded. I have recorded somewhere. I had written because it was also in my mind.
IA is known to me.
IA.
EO, PO, CO is
Yes, my
I
lord.
just inquiry authority.
Inquiry authority. Is correct.
Authority.
Inquiry authority.
Inquiring
Is correct.
officer, but authority.
Authority is correct. IA stated that same request to be justified as and when the situation arises. Now, my lord, CO submitted the following defense documents for his defense. So it's 1, 2, 3, my lord, DD1, DD2. It was marked. All these were marked also. DD1, DD2, DD3, DD4. Now, if your lordship kindly turns to the next page.
Just a minute. Copy of the performance rating, copy of certificate of test manager, copy of FIR lodged during my tenure at Shampur B. Colliery. That is the FIR against D3.
D3, my lord, copies of
Yes,
FIR
yes, my lord.
during
That
my
is the
tenure,
FIR.
Shampur B. That is the FIR.
Letter addressed to area security officer, Koma area regarding illegal mining. Address to CISF. Letter addressed to CISF regarding list prepared. The list prepared by reports by Salim. Certificate of pressure training issued by Salim as per mine location of office file. List of using being deployed on surface file. List of using on surface. Yes.
If your lordship comes to the next page, my lord, it continues, my lord. The now documents, after the documents, my lord, thereafter in the page at page 180, my lord,
Just even additional documents, if any arising out of in course of the proceedings, will be submitted inquiry authority. List of defense witnesses.
Practically, my statement has not been recorded as yet. And apart from this, my lord, I have sought for some other document.
When yes, it is dated 30th October 2025.
yes, 30th October 2025, and there are two representations
So you have
of
already
that date,
disclosed the
of that.
evidence.
No, my lord. Kindly
And
come.
have you taken this point? Did you take this point?
Yes.
That due to pendency of the criminal proceedings,
Yeah,
my right will be affected.
Yes, my lord.
Where you have stated?
My lord, page 146.
What is the date?
On 30th October 2025.
Lord, I have stated, my lord, they have not recorded. But apart from
No,
this, my
Where
lord,
you have stated in the writ petition that you took this point and it was rejected on 30th October 2025.
my representation kindly see, my lord.
In the writ petition, body of the writ petition, where you have
In the
stated.
body, my lord, I have stated that it will prejudice my right. First thing, my lord, if your lordship kindly come, my lord.
Question is, in other matters, there was no commencement of inquiry.
Here, my lord, I have
In
not
this
disclosed.
matter, there is commencement of inquiry.
That
you participated in the inquiry proceedings.
But my lord,
you disclosed your documents.
But
Now, after that, what remains?
my lord, the examination and witness examination, cross examination, nothing has been started. Only FIR and etc. All
Everything based will be based on this disclosure of materials.
my
That already happened in 30th of October 2025. There is a judgment in Ramjan Khan or that it is stated it was decided considering Impol Antony that on case to case basis it has to be considered. There is no straitjacket formula.
Kindly come
Kenja
page
Vidyalaya judgment.
page
There is
128.
also Kenja Vidyalaya, which was
Kindly come
passed in
page 128,
2004.
my lord. Page
131 prior to that, my lord.
I could understand that at the commencement of the proceedings, you did take this point that disclosure of documents or disclosure of defense material, disclosure of materials would prejudice you in defending yourself in criminal proceedings. Then I could understand. But you have submitted, you appeared before the inquiry officer, you disclosed documents without any demur. And there is no statement in the writ petition that you tried to resist this or you tried to persuade the inquiry officer not to compel the delinquent employee to disclose the defense at the stage. You did not take this point in the writ petition. There is no such whisper.
I understand, my lord. If you lordship kindly come page 128.
Rather, my lord, why this statement recorded, my lord? Come to page 131 first.
I have fought for some other documents. They have not supplied as yet.
Kindly
come to my learned friend is already finished, my lord.
No, I have not
Lordship's query, my lord. Kindly allow me, my lord, to
kindly come
resolve
to
that
page
matter, my lord.
131 when of the same date, 30th October 2025, where he has made this
30th October
of 2025, page 131 and 133. These are the two letters disclosing his documents.
It's an afterthought proceeding.
So kindly come page 128.
Subsequently, petitioner became wiser.
No, well, another
this avenue is open to me.
No, kindly come on page 128, my lord.
Yes, 135.
131 and 133.
128, if your lordship kindly come.
Only after supply of essential and crucial documents. It's not that you stay that.
And my lord, till date, my lord.
That's a separate aspect.
And my statement has not yet been recorded as yet, my lord. Some supplying of the document on an ongoing process.
also.
Yes, certain documents were requested to be supplied to the
The
petitioner.
IA is taking steps, my lord.
Not yet, my lord,
IA
supply.
is taking
My
steps.
lord,
Certain
supplying of the
documents-
FIR and my
but that
appraisal
does not
report.
mean that is his defense
My lord,
witness.
page,
This-
my lord,
there can be
paragraph
two
14,
steps.
my lord,
Only
paragraph,
either those are
my lord,
our
paragraph
documents.
14.
Just a minute,
My
let him place his case.
My lord.
It
I have
means,
heard you.
it means either those are our documents which he is seeking for, our documents, or if it is his documents, then also the defense is disclosed. So that letter will not make any
But
difference.
defense
His
will disclose as
particular-
an.
Allow him. What is this, Mr. Ghosh?
My lord.
So his particular, by way of writing two letters, he had disclosed his defense witness and defense documents both, which were recorded in the proceedings of 30th October 2025. Now he has, as rightly from your lordship, he has become wiser and has come that I can explore this avenue. And every case, as your lordship knows, it's not to be stayed. It's case to case basis. I have, my lord, 3-4 judgments with me. I'm not bothering your lordship.
My
with that.
paragraph 14, if your lordship kindly come of my writ application.
Now, after disclosure of materials,
My lord,
how you will be prejudiced? Please demonstrate.
my lord, first thing, my lord, I have not even, my lord, cross-examined the witnesses.
Yes. If the materials are before the inquiry officer,
Material, my
then
lord,
what is the harm in cross-examining the
my lord,
witnesses?
material is only, my lord, FIR.
Yes.
My appraisal report. So
Yes.
it is whether I disclose or not, it is already on record.
No,
FIR.
demonstrate that after disclosure of in two other matters where I have protected the petitioners, there was no commencement of inquiry.
No, there was also comment.
Yes, but there was no disclosure of evidence.
Here, my lord,
There was no disclosure of defense materials.
my lord,
So far, charged officer is concerned.
my lord.
But in this case, already the inquiry proceeding is commenced, and you have disclosed your defense materials before the inquiry officer.
Only some.
After that, what is the concept of restraining the inquiry officer not to proceed with the matter? If defense materials are placed and disclosed by the delinquent officer during pendency of the criminal proceedings, then petitioner or the delinquent employee may be prejudiced in criminal
My lord,
proceedings in defending his case.
I understand.
But in this case,
My lord,
already you have disclosed defense materials without any demur.
my lord.
Now, after disclosure of defense material, now you have became wiser and submitting, no, you cannot proceed further.
Now, my lord, kindly come paragraph 14, my lord.
Show me your reply to charge sheet that you have taken this point, that at this stage you are not that the inquiry officer should not initiate the proceedings in view of pendency of the criminal proceeding. Show me from the reply to the charge sheet, Mr. Ghosh.
My lord, I am coming that, my lord. Before
No, please answer the query of the court first.
my lord.
Show me from the reply or response to the charge sheet that you have taken this point.
Reply to query.
The second reply, first reply also.
No, before that, my lord, if your lordship.
No, not before that. First, satisfy the query of the court.
Page 90.
6, my lord, if your lordship
Page
kindly come.
Page
90.
90.
90.
90. It has to be assessed in on case-to-case basis. Show me that in the reply to your charge sheet, you have taken this point that the inquiry officer is not supposed to proceed with the inquiry proceedings in view of pendency of the criminal.
But till that date, my lord. Huh? কি বলছিস? So P8, if your lordship kindly come.
Yes, page 90, 11th August 2025 is the reply to the charge sheet,
No,
written submission.
there are another reply also, my lord.
Another reply. It's a continuation of that.
P8.
Page.
P8, my lord, page 108.
Same thing.
My lord, at the time of reply to the charge sheet, this kind of, my lord, defense, possibly it's not, my lord, required.
Why not?
as
It's
to-
it's a deliberation from the charged officer.
As to why,
He should take this point first, that in view of pendency of the criminal proceedings,
because-
disciplinary proceedings should not be
because-
initiated by holding inquiry, by drawing up inquiry proceeding.
because after the, my lord, the reply is filed, they may drop the proceedings. I am not aware that whether
No,
they
no,
will, whether
that in anticipation, you should not restrain yourself from taking this point.
my lord, after participation,
Very well. During the criminal proceedings, you show me, inquiry proceedings, you show me that you have taken this point.
my lord, I have, my lord, written, my lord,
You show me that in the criminal procedure, in the inquiry proceedings, before the inquiry officer, you took this point that not to proceed with the inquiry in view of pendency of the criminal proceeding.
my lord, page 143, if your lordships kindly come.
Subsequent to the date of disclosure.
No, disclosure, my lord, I am coming, my lord. Page 143, if your lordships kindly come. No, not 143. Page 146. 146, yes.
After 30th of October 2025, I will not consider.
Now, if
Before that, you show me.
my lord, law is now, if your lordships kindly allow me, my lord, to compare two witnesses. Only, my lord. Kindly come, my lord. Page 39. Kindly come.
My lord, I standing here, I do admit there are witnesses
Page-
who are common.
Page 39. So let them, my lord,
Do admit.
let
But
them, my lord,
does not-
disclose.
That does
These
not mean
witnesses
that-
has been examined. These witnesses has been,
disclosure.
no. As and when these witnesses will be examined, then only my defense will be disclosed. I have simplicity to disclose the FIR, that will not suffice.
Not FIR, the entire list of documents and witnesses.
My lord,
Yes, page 39.
page 39, kindly see list of witnesses by whom the article of charges are proposed to be sustained. So these are the person who will sustain, who will, my lord, prove the charges. Let they show, my lord, that this person has been examined. As and when
These persons,
has been examined, and I have been examined them. Then only my defense will be disclosed.
Cross-examination defense cannot be disclosed. The concept of
And now compare
cross-examination is something
with
different.
the CBI, the witnesses in CBI, page 58, same persons. Ultimately,
Muhammad Salim is the complainant.
complainant.
Muhammad Salim's FIR has already been filed, copy of the FIR before the inquiry officer.
Very well, my
What
lord.
remains?
Then other persons,
Whatever he will depose, that will be in the FIR.
yes. Now, my lord,
So you have already submitted FIR before
FIR
the inquiry officer.
My
Yes, please come to the relevant part of the this document, page 116. Page 117, we at the bottom, second table, against defense DD3, copies of FIRs lodged during my tenure at Shampur. B. Colliery as a manager of the mine. You have already disclosed. So what else Muhammad Salim will depose?
No, apart
It
from
has to be based on his complaint.
yes.
That is part of FIR.
Now I understand. Now, my lord, kindly come Rothin Kumar Das. The other, my lord, witnesses kindly come page 39, all witnesses, and then, my lord, page 58, all witnesses from CBI. Till date, these persons were not, my lord, examined. Only simply, my lord, I filing the FIR will not disclose my defense. Whether I disclose or not, it's immaterial. Page 39, you also will find the persons from the charge sheet. And page 58.
No, Mr. Ghosh, you have to show that you have taken this point at the time of responding to the charge sheet, and during course of inquiry, you raised this issue that similar issue is pending before the criminal court.
My lord, page, my lord, paragraph 14. If your lordship kindly come, my writ application as is.
Because it is a different case. Much water has flown through river Ganges.
The persons, my lord, will disclose his defense as and when, my lord, I will submit my statement.
Issue.
Paragraph 14, if your lordship kindly come on as the last, my lord. Paragraph 14 of the writ application.
Paragraph 48 of the writ petition.
1-4. of the writ application.
এই একটু রণজিৎকে ডাকো তো। Yes, where is the objection raised by the petitioner?
Because, my lord,
And where is the averment that you took this point and it was negated by the inquiry officer?
Lord, as in when, my lord, the person, those, my lord, kindly, my lord, consider there are 10 witnesses in each, in disciplinary proceedings and, my lord, the departmental proceedings. So, as in when these witnesses will be examined, then only my defense will be disclosed. I have no case. But till date, nobody has been examined. And I have not submitted any, my lord, any statement as yet. No cross-examination, no examination, no, my lord, statement from my side. Nothing has been. Only, my lord, since that was, my lord, continuing. And, my lord, I expect that someone has got the stay from the same proceedings, from this honorable court. They will also follow that, my lord, order. But they have not followed from the same, my lord, proceedings, because ultimately two persons has to be examined. Myself and the another person who has, my lord, came before this honorable court. He has got stay. So ultimately his examination will also not be possible. Then
Where
ultimately,
is that stay order?
my lord, kindly see.
My lord, I do not know, my lord. In Gauravani, my lord, there was a
Kindly see.
primary.
There is jurisdiction point. So
Whether
that is
that
separate.
jurisdictional point has already been, primarily a stay was granted, but the jurisdiction point was argued, my lord, whether thereafter, my lord, because in that matter, my lord, it's in Mugma area, because he was a, my lord,
Justice.
non-executive.
Justice. there this aspect was not considered, that already inquiry proceeding commenced and you have disclosed your materials before the inquiry officer.
Ultimately, if it is, my lord, in same proceedings,
It is not
Not the same
considered.
in a same proceedings,
Not same.
in
Why,
same,
my lord?
in same
Why? No. Here, my lord,
criminal
he is
proceedings, my
misleading,
lord.
He is
In
now I'm
same,
saying, I will
well,
say
I
he's
have the
misleading.
brief.
Why not same proceeding?
Why not, my lord? My lord, kindly see the first. But go on is, my lord. It says that the petitioner is an employee of the coal company working as a general mazdoor,
Yes.
the non-executive. He is governed by CSO, certified standing.
Ultimate
certified
principle is the
standing
same.
order. Now, if your lordship
I
considers
have the
the
brief.
charge sheet,
I have brought the brief. Your
Charge
lordship may
sheet,
check up the brief,
maybe
my lord.
it has arisen from the same fact, maybe. But the
Same
charge
CBI
sheet here is
case.
different, maybe.
Same CBI
But
case.
here the charge sheets are different, my lord. It is if your lordship considers the charge sheet at page 33, to whom it was given, not to Gauravani. Because this petitioner is an executive. He is governed by CDA rules. And he is governed by this Gauravani is governed by CSO.
Manager of a colliery.
Yes,
Yes.
he is executive. He is governed by CDA rules. And while he is governed
That
by
is
CSO.
whether they are whether issue is same or not. That is now what is troubling this court is this, that already petitioner appeared before the
Yes.
inquiry officer and disclosed
Disclosed his-
materials,
That not
disclosed
only
evidence.
evidence.
My lord, with due
Documents
respect,
And after that, petitioner has taken a turn and
Yes.
has
Yes.
approached this court.
Yes.
my lord, with due respect, if your
There's a
lordship,
somersault and then approached this court.
no, my lord, here, if your lordship kindly see, my lord, the page 125, my lord.
All matters will remain, my lord. No disciplinary proceedings, CBI proceedings will go on. They will take this.
But whether you have issued the charge sheet based on CBI charge,
Yes.
My lord, now
Yes.
now I come, my lord. Now I come. If your lordship is asking me, now I will, my lord, tell you. My lord, if there is an incident, if there is an incident, and from which criminal proceedings and disciplinary proceedings are arisen, so the fact will be same always. Fact will be, we have stated the fact that on that day, these things happened. CBI has made a raid. You are caught. You are taken by the CBI, and these things happen. Now, as you are
now
guilty
tell
of
me,
this,
there is
Yes, madam.
another aspect which needs to be gone into.
yes,
Suppose court permits you to initiate proceedings.
yes,
Charges are proved in disciplinary proceeding.
yes,
Petitioner is terminated.
yes.
But subsequently in the criminal proceeding, if petitioner is acquitted, what will happen?
Then there are judgments, as your lordship knows, my lord. The procedure in the two proceedings are different. One is on the preponderance of probability. Why, my lord?
But the issue is
No, it's
same.
not direct. Not direct. Here, my lord, there are other charges also. Not only one bribery.
No,
There are
there are no other charges. And there was no complaint against me before the coal company.
that does not
There
require.
was
There
no
is no
complaint.
independent charge leveled by the discipline authority.
Yes.
It is
Yes.
it is based on the FIR.
Yeah.
No.
Based
It's
on the
based
charge.
on the fact. I'm not saying it's based on the
So
FIR.
tell me then what will happen?
My lord, it's not that. It's not the case, my lord. Everywhere, even considering Maharana Pratap's case, my lord, where if your lordship, as lordship has gone through there, my lord, in the disciplinary proceeding, the witnesses, they could not prove the charges. And there was an acquittal. That's why. There are, my lord, Balvinder Singh's case also.
I am asking you a situation
Yes.
where if the charges are proved,
My lord, it's
petitioner
not,
is terminated, then he ultimately in the criminal proceeding, petitioner is acquitted.
my lord, it is not directly proportional, my lord. It's not that. In every case where he is acquitted, that the disciplinary proceedings will also be governed by them. It's not that. It's case to case basis again. It's case to case basis again. If I can
One is preponderance of probability, as
Yes.
in another in
Beyond
criminal case, it has to be proved beyond doubt.
beyond doubt.
These are the tests.
These are the
So the level, the tests are different.
tests are
Yes,
different.
but issue is same.
Issue may be same, my lord. And there are other issues also. There are other issues.
What are the
also.
other issues?
My lord. Articles of charges, my lord.
What are the other issues?
Page 35. Well, then otherwise, no disciplinary proceedings will proceed.
Yes, what are the other issues?
Well, kindly say.
Otherwise, no disciplinary proceedings can be initiated.
No, they will, my lord. If
If there are
any
independent charges, who prevents you
No,
to initiate
if
proceedings?
in every case where there is a criminal proceedings,
Yes, show me what are the other issues.
my lord, kindly see. Page 34, my lord. Statement of articles of charges. I've come to the, my lord, last paragraph. Duties and obligations of executives, which we have narrated. Rule 411. Every employee of the CPSC shall all
Where, yes.
page 34, last paragraph, my lord. Duties and obligations of executives. Every employee of the CPSC shall at all times maintain absolute integrity.
That is related to that incident. These are the
Incident, my lord,
ancillary charges.
my lord, your lordship is correct.
Uh,
Incident will be the same. In a case, my lord, where disciplinary
Show me
proceedings,
my order.
Yes, I have given, my lord. 2 orders I have given.
my lord, once and that will be in Paul Antony and everywhere, my lord, once defense is disclosed, my lord, then what remains?
But the set of witnesses are same in both the.
No, it's not that. Then, my lord, allow me to place my judgments. On the other day, your lordship passed that order, my lord, based on the judgments and in Paul Antony. I have the other judgments too. Maybe the same. But once the defense is disclosed, what remains?
The procedure is that it is narrated in the order of Justice Rai also that the CBI submits its charge sheet before the jurisdictional criminal court and the same is served upon the coal company.
Yes.
On the basis of such charge, the coal company issues charge sheet.
Yes, same.
My lord, it's case to case basis, my lord. Again, my
Yes,
lord.
case to case basis, whether it has happened in this case or not.
In Gaurav,
When you have issued charge sheet,
no.
after filing of charge sheet by the CBI in the criminal case.
Yes,
Ah,
yes,
Ah.
yes. Now, my lord.
ah.
Now, may I place my judgment?
You reserve these things because today I am not deciding the issue. I will restrain you and the matters to be decided on exchange of opinions.
My lord, kindly, my lord.
Yes,
Again, my
yes.
lord.
No.
But what about my lord? This defense is already disclosed. Defense is already disclosed. So how he is prejudiced?
Yes, yes. But the witness action is still remains.
Witness action remains.
Deposition,
Defense is disclosed.
deposition of the
My lord,
witnesses are not
Lord,
complete.
kindly consider one aspect, my lord. Deposition.
If same set of
That-
witnesses
My
depose
lord,
before the inquiry officer, thereafter what remains before the criminal procedure?
No, they are, my lord, my lord, kindly consider one aspect. One aspect.
Issue.
My lord, kindly
You
consider.
have tried your best. Yes. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph.
Affidavit service file earlier occasion.
Earlier occasion. আচ্ছা, কেটে দাও। Matter is heard at length in presence of the learned advocates representing the petitioner and Eastern Coalfield Limited. And the Eastern Coalfields Limited within bracket for short ECL. Question, no, stop. Next paragraph. Learned advocate representing the petitioner submits that that disciplinary proceeding is initiated based on charge sheet dated 4th April 2025. And it is also stated, and it is also submitted that inquiry is continuing. At present. In connection with DCPA proceeding, preliminary hearing was conducted on 17th October 2025 and thereafter inquiry was held on 30th October 2025 and 6th November 2025. Stop. Nature of charge in both the stop. Where is the particulars of criminal proceeding?
Page 47.
47.
It is further next paragraph. It is further contended on behalf of the petitioner that based on an FIR dated 27 September 2024, a criminal proceeding was initiated before the jurisdictional criminal court under section 61 BNS 2023 read with section 7 of Prevention of Corruption Act 1988. Stop. In the said criminal proceeding, charge sheet was issued on 26 November 2024, being number 13/2024. Stop. Next paragraph. According to the petitioner, nature of charges in criminal proceeding and disciplinary proceedings are similar, and prayer is made to restrain the inquiry officer from proceeding further. Otherwise, petitioner would be prejudiced in the criminal proceeding. Next paragraph. In support of submissions made on behalf of the petitioner, reliance is placed on the judgments of the Honorable Supreme Court reported in 1999, Volume 3, SCC 679, within bracket Captain M. Paul Anthony versus Bharat Gold Mines Limited and another, close bracket, comma, 2023 SCC online SC 1618, within bracket Ramlal versus State of Rajasthan and others, and 2025 SCC online SC 890, within bracket Moharana Pratap Singh versus State of Bihar and others. Stop. In addition, there are two reliances also placed on the orders passed by the coordinate order passed by coordinate benches on the writ petition being WPA 13934 of 2025, within bracket Bipin Kumar versus Eastern Coalfields Limited and others, comma, WPA 29425 of 2014, within bracket Gautam Mondal versus Eastern Coalfields Limited and others, close bracket. And the order dated 19 June 2025 passed on. Writ petition being WPA 12647 of 2025 within bracket Gaur Rawani versus Eastern Coalfields Limited and others, close bracket. Next bracket. এটা না এই পুরোটা পেয়ে যাবে এখানে তোমায় দেখিয়ে দেবো এইটা হচ্ছে গোলাম রাওয়ানিটা এখানে লাস্ট পেলাম যার ফলে তোমার সুবিধা হবে আমি এই পাশটা পাশে না দাগ দিয়ে দিচ্ছি একদম সেম প্যারাগ্রাফ এটা লাস্ট প্যারাগ্রাফ নেক্সট প্যারাগ্রাফ Mr. Manik Das, learned advocate representing Eastern Coalfields Limited, has opposed prayer for interim relief to the extent of restraining inquiry officer from proceeding further in the inquiry proceeding in connection with disciplinary proceeding drawn up against the petitioner. Stop. It is submitted that petitioner has participated or hashtag carried out. It is submitted that petitioner participated in the inquiry proceeding by appearing before the inquiry officer on 30 October 2025 and 6 November 2025 without any demur, and disclosed and submitted and disclosed evidences in support of his case. Stop. Such disclosure of evidence took place on 30 October 2025 as it appears from page 116 and 17, 117 of the 116 to 118 of the writ petition.
And also, my lord, 131 to 135.
Stop. According to the respondent authorities, after disclosure of evidence by the petitioner before the inquiry officer, continuation of inquiry proceeding may not prejudice him in the criminal proceeding. According to the learned advocate, according to the respondents, each case has its own features based on separate facts. Those are required to be examined while considering prayer for interim relief to the extent of restraining the inquiry officer from proceeding further. Stop. Next paragraph. On perusal of relevant records and in consideration of submissions made on behalf of the parties, it appears that one Muhammad Salim, working as General Mazdoor in Shampur B Colliery, made complaint against the petitioner alleging demand of bribe by the petitioner to retain said Muhammad Salim at the same place of posting. That is magazine/explosive room at Shampur B Colliery, ECL Dhanbad. Stop. Based on such complaint, dated 11 September 2024, CBI initiated Central Bureau of Investigation within bracket CBI. কেটে দাও এত কথা বলা যাবে CBI initiated criminal proceeding which is pending before the jurisdictional criminal court. Stop. It further appears initiation of disciplinary proceeding by the respondent authority is based on charge sheet submitted by CBI on 26 November 2024 in the criminal proceeding. Comma, charge sheet was issued on 4th April 2025 containing similar charges as containing charges rest on same incident of incident of bribery against the petitioner. Next paragraph. It is true, as it is contended on behalf of respondent authorities, that petitioner participated in the inquiry proceeding before the inquiry officer in connection with disciplinary proceeding on 30th October 2025 and 6th November 2025, and there was disclosure of materials by the petitioner on 30th October 2025. But what is striking is witness action is yet to be commenced. Stop. It further appears that same witnesses will depose in criminal proceeding as well as in disciplinary proceeding. Same set of witnesses. Stop. Therefore, if witness action is complete in connection with the disciplinary proceedings, petitioner, there is possibility that petitioner would be prejudiced in the criminal proceeding, considering common issue involved in both the proceedings. Next paragraph. In consideration of aforesaid developments which took place in disciplinary proceeding, court is of the view that disclosure of materials in disciplinary proceeding, disclosure of material in inquiry proceeding on the disclosure of materials in inquiry proceeding on 30th October 2025 by the petitioner ought not act as fetter in protecting his right to defend himself in criminal proceeding. Stop. Next paragraph. In this regard, this court finds it apt to rely upon paragraph 22 of the judgment of the Honorable Supreme Court, delivered in M. Paul Antony Supra, M. Paul Antony bold hobe, Supra, which is quoted below. এ দেখো এটাকে সেট আউট করে দিই, ঠিক আছে? নেক্সট paragraph. In aforesaid conspectus, inquiry officer the inquiry officer shall not proceed further in connection with disciplinary proceeding initiated against the petitioner based on charge sheet dated 4th April 2025. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. No, be filed by 2 weeks. Be filed by 1 week after the ensuing Christmas vacation. Stop. Reply. The affidavit in reply thereto, comma, if any, comma, be filed by 2 weeks after. By 2 weeks thereafter. Next paragraph. Party shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. Leave is granted to ECL authority to approach this court by filing appropriate application seeking variation or vacation. Seeking variation or vacation of this order in the event ECL authority finds that petitioner is trying to defer the proceeding pending before the criminal court unnecessarily. Paragraph 11 টা সেট আউট করে দেবে, তাহলে এটা পেয়ে যাবে, হয়ে যাবে। এটা সেম, বুঝতে পারছো? Yes.
Item number 10. Your Lordship is a RPF constable attached to Malad Howrah Division. Now, on the occasion of inauguration of a train in 2022, the petitioner and some other persons from Malda divisions, they were directed to join at Gadda railway station at Jharkhand. So they were there, where incident took place with the local person as well as a police officer of the.
You are representing
I'm for the respondent number
respondent number
4, my lord.
who are representing others.
Like they made the party the Director General of Railway Protection Force, Inspector General. They are not, in fact, they are not the approved party here. Though they have made the application for my lord, they are before the Inspector General. That's why they made them party. Unanimity is a necessary party. That's why unanimity.
Yes.
Unanimity is a necessary party because the railway is under the Union of India, my lord. That's why, my lord.
Who is appearing for Union of India? Uday Shankar Bhattacharya and Subhajit Das.
My lord.
You are representing only respondent number 4.
Well, in fact,
not
respondent
3, 2, and 5.
Well, respondent 4 is the, my lord, effective.
I am asking you whether you are representing 2, 3, and 5. They are also the authorities under the Eastern Railway.
Yes, my lord.
Are you representing or not?
Yes, yes.
So then why you are saying 4?
No, I am saying because, my lord, the respondent number 4 is the effective respondent who will give the answer of everything. Other is unnecessary. They have made the party, my lord.
Yes.
Now, my lord, a court of inquiry was set up with 3 months committee. He filed his, my lord, report that yes, our disciplinary proceeding may be initiated against 3 persons. Accordingly, my lord, charge sheet was there against this particular petitioner and some other persons. Now, inquiring of the authority, disciplinary authority is our concerned department. That's the division. Since I was attached to the Howrah division, my authority is Howrah division, and for others, the Malda division. Now, my lord, inquiry officer was assigned. Now, inquiry officer, after completion of his job, he said the petitioner is not guilty. The disciplinary authority, they gave a note of disagreement. They proceeded against.
Authority can.
Yes, yes. They proceeded against
Kunjo Bihari's case.
They proceeded against me.
Kunjo Bihari versus PNB.
Name is
Yes.
Kunjo Bihari something. Now, my lord, the petitioner was punished with, my lord, loss of increment with cumulative effect for 1 year. He preferred appeal.
Departmental appeal.
Departmental appeal affirmed the order of the disciplinary authority. He went for, my lord, revision. Now, revisional authority modified this order. It says instead of 1 year, that should be 6 months.
So you are challenging these 3 orders.
Yes,
What is the scope of interim order?
There is no scope for interim order. Only one thing I will show before lordship, the perversity. What are the charges against me and what is the finding of the authority? It says you had to report Mr.
At
X.
this stage,
Direction for it.
court should not exercise its power of judicial review, but let there be direction, because you are only the punishment is to the extent of withdrawal of incremental benefits.
Incremental benefit for
For a period of 6 months,
with
that has been
cumulative effect.
that has been modified by the revisional authority. What was the order by the revisional authority?
It says 6 months with cumulative effect.
Oh.
And well, for others,
So order of the disciplinary authority was 6 months
1 month.
without 1
1
month
month
without cumulative.
1 year.
with cumulative effect.
1 year.
1 year with cumulative effect. He says 6 months with cumulative effect.
So punishment become lesser
Lesser.
in terms of the order of the reviewing authority.
And it's my information that
Where are the order of the disciplinary authority,
My-
appellate authority, and revisional authorities?
your lordship will get at page 114 the order of the disciplinary authority. The concluding portion at page 119.
Whether revisional authority, while differing the view expressed by the disciplinary expressed by the inquiry officer, whether fresh hearing was granted.
Sharing this. Yes, ma'am.
Fresh proceeding was
No.
there was a compliance of natural justice by the
Compliance
disciplinary
of
authority.
natural justice was. They said it's harsh, so that was reduced. No,
Read Kunjo Vihari.
there
Their Supreme Court has dealt with the issue,
let me take it.
stated that in a case, plus Mr. Jahan first heard this court. that stated that suppose a report is returned, a finding is returned by the disciplinary inquiry officer. That may not be accepted by the disciplinary authority. But disciplinary authority, in case of disagreement with the finding returned by the inquiry officer, he has to follow the procedure in order to come to a different conclusion. That is the observation made by the Supreme Court in Kunjaviyari's case. Whether that procedure was complied with, I'm asking you. You should know, you are the lead counsel in this matter.
I was given
You should know this
I
thing.
was given an opportunity to oppose the finding of disagreement.
Then there is a
That
complaint.
opportunity was there. That I have annexed.
In some of the cases, it is found,
No, that was
generally it is found that there is a lacuna to that extent.
Now, one thing I must indicate before Lordship, in respect of other 3 persons who are under the Malda division, they also suffered the punishment, but their punishment is
So
non-cumulative.
the opportunity of hearing was granted by the disciplinary authority.
Yes, yes. Now, my lord, in case of those 3 persons whose authority is the Malda division, my lord, they have been punished with non-cumulative curtailment. That's the difference in between me and those persons, since our division is different. I am from my lord, Howrah division, and they are from the Malda division.
Nature of punishment is different.
Yes, yes. But the curtailment of withholding of annual increment, that is same, but with cumulative effect and without cumulative effect. So I am suffering.
But so far the disagreement, to the extent of disagreement, procedure was followed. Well, come at to.
Great.
Then there would have been a scope of interfering with the order passed by the disciplinary authority. State were relying upon Kunjaviyari. Yes.
Case 100 is the fish under which the disagreement memo was served upon the petitioner, that is dated 16th of May 2023, and that allowed the petitioner.
Page 100.
Case 100, one. Second paragraph shows 10 days time was given to the petitioner to file his response, written response.
That is after submission of inquiry by the inquiry report. It was before the disciplinary authority. So where is the order of the disciplinary authority?
Now I filed my response, but no hearing was there. I filed my response in terms of this notice, but no subsequent hearing was given to this petitioner. Now under the order of the punishment that starts from page 114. Penultimate paragraph.
Did you take this point before the appellate authority? That no.
I must be candid for lordship, that's one. I cannot improve that. Now page 119 is the penultimate paragraph. Last paragraph, bold letter, my lord. Withholding of next annual increment for a period of 1 year with cumulative effect. To meet the
Now this is the departmental discipline authority's order. Then where is the order of the appellate authority?
Now the order of appellate authority, your lordship will get it at page 120. 120.
The order of punishment remains. Then the review authority.
Then review. It's
Or revisional authority.
Revision order, that order is at page 123. The modification that was made, my lord, at page 129. After this revisional order, my lord, the petitioner filed.
No, where is the order of the revisional authority? It says in pursuance of the order of the revisional authority, that is DIG cum CSC ER Kolkata.
Yes, for page 129 is the conclusion portion, starts from page 125.
Yes, sir.
Now, may I indicate two things to your lordship? Your lordship permits me that the charge sheet says I had to intimate this fact to the in charge. Now the court inquiry which was conducted says he was not at the place, he was elsewhere, and he was not.
That is relating to charge.
Yes.
So that will be decided. Yes. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. In the writ petition, order of the disciplinary authority dated 29th May 2023, comma, order of the appellate authority dated 28th July 2023, and order of the revisional authority
20th December 2023.
dated 20 December 2023 are questioned, whereby punishment was imposed upon the petitioner to the extent of withholding next annual increment for a period of 6 months with cumulative effect. Stop. order of punishment of the disciplinary authority was modified by the order of the divisional authority. And less punishment was imposed. Next paragraph. Railway Authority, Eastern Railway. How this? Eastern Railway is Eastern Railway authorities are represented by learned advocate. Stop. Next paragraph. There is no scope for passing interim order. Stop. Issue involved in this writ petition needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 1 week after the ensuing Christmas vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
2 weeks after vacation.
Then by 10 days, file it.
Extremely good.
Then by 10 days from date,
No, my lord,
peremptorily. Please don't bargain.
extremely good. No, my lord, only I am messaging your lordship, my lord. In this
Next matter, please reserve your energy for at the time of hearing for the final hearing.
Item number 11.
Lordship, item 11, I appear for the Union of India, Your Lordship.
I appear for the respondent number 2 to 5, my lord.
Lordship, I am for respondent number 1.
But 2 to 5 is the main answering respondent. I'm appearing for the 2 to 5.
Yes.
But this is payment of post-retirement benefit against this institution earlier bunch of writ petitions were filed similar orders have been already been passed I will be praying for similar orders only one thing one of my learned friend knows this I only appeared and he appears only one thing kindly see the rate of interest has been given as 6%.
I also
Yes.
grant 6%.
Yes, yes. But only one thing, when I moved those bunches of writ petition, I did not have one notification in my hand, which I have annexed here. If your lordship would kind enough to comes to page 22, annexure P6 of the writ petition.
এই খোলা গরম করছে
What happened, this is another employee of the same company, who filed an application under Right to Information Act. Now, page 25 and 26 are annexures to
I don't follow, couldn't follow page 22.
Yes, I've given a translated copy at page 27 I given a
Page 22 is a mere
Definitely.
letter.
Yes,
Nothing
yes,
is there with regard
yes,
to
yes.
interest.
25 and 26 are annexures to that is the forwarding letter. 25 and 26 are in Hindi that's why I have given a translated copy at page 27.
That is under the Payment of Gratuity Act.
That is that.
It is a case where payment there is a delay in making payment. If payment would have been made on the date of your retirement,
Yes.
then what interest
Then
you would
the
have earned?
Milord, here, Milord,
Then
my
the interest at which rate you would have earned?
10%, because here, Milord, gratuity has been paid, Milord, after much delayed period.
Sorry.
Much delayed period.
Yes.
Milord.
The statutory interest.
But here, Milord, in this case, Milord,
So what benefit was not paid?
Milord, 16 lakhs, 2019 and 720
that?
as PL
Provident fund.
encashment.
Provident fund.
PL encashment. And Milord, interest on delayed payment of gratuity.
But it is a case of on-leave encashment.
Yes.
Same. PF encashment.
PL. Leave encashment.
Leave
On-leave
encashment.
encashment. PL. Now, there are others also, Milord.
On-leave means EL encashment. Why PL?
Milord, kindly see, Milord, I have annexed, Milord, page 20, Milord, kindly see. This is, Milord, the worksheet they have given me on the date of retirement.
So are you claiming interest on leave encashment?
Both, Milord, interest on gratuity and leave encashment.
When the gratuity was paid?
Gratuity, Milord, was paid, Milord. Milord, retired on, Milord, 28 February 2023. And
Milord, kindly takes up page.
Just a minute. 28 2023. Yes.
17 June 2023. Gratuity was paid on 17 June 2023.
And other benefit?
Provident fund is paid on 31st March 23.
Yes.
31st March 2023.
Yes.
Date of
So only payable amount was amounts were under gratuity and provident fund.
that has been paid. And the PL, paid leave, is yet to be paid. And none of the representations of the petitioner, which are annexed with the writ petition, where petitioner has not claimed any interest on gratuity. It is the submission made on behalf.
So there was delay in releasing gratuity and provident fund also, which requires payment of interest.
My lord,
Maybe at the lower rate, but which requires payment of interest.
my lord, kindly
28 February 2023, June 2023, and March 2023. You are required to pay the benefits from the date following the date of retirement. So that is from 1st of March 2023.
The provident fund has been paid on.
The payments are required to be made under three heads. One is provident fund, another is gratuity, and another is leave encashment. Leave encashment. Leave encashment is yet to be paid.
Yes, yet to be paid.
So leave encashment needs to be paid immediately.
That's
Milord,
Have you prayed for a direction for payment of leave encashment benefits?
Yes. Prayer, Milord, kindly comes to, Milord, page 11. And leave encashment.
It is to disburse the
Prayer,
leave encashment.
Issue. Milord, only one thing, Milord. I may be permitted to rely upon, Milord, one judgment, Milord, of Karnataka High Court. Milord, this is a, Milord.
Very well, then rely upon. Let me give direction for exchange of affidavits.
No, Milord, only
then
on
matter to be
interest
heard.
part. Only on
Yes, yes,
interest.
yes. Then matter to be hard on affidavits
Then,
regarding quantum of interest.
sir, then my lord.
Petitioner was employee of
But may I be permitted to say something before your lordship comments this, my lord? My lord,
yes.
the representations which they have made, in that representation, they have only paid for interest on the privileged leave encashment and no interest on gratuity or provident
But
fund.
in the writ petition they have paid for.
In the writ petition for the first time they have came up.
Yes,
Statutory duty.
that you have to pay. We have made the delay in releasing the same. There is no purpose. No purpose would be served in giving direction to consider representation that will be rejected and they will come back before this court. That I will not permit. It is Industrial Training Institute.
Indian Telephones.
The ITI Limited.
Yes. ITI Limited is Indian Telephone Industries Limited.
Oh.
Tel
Under which department?
Department of Telecommunication.
Telecom.
Lord.
Indian Telephone Industries. Where you have stated the full form.
Indian Telephone Industries Limited. Will annexure P1, page 6 at the top.
So it's not a central government service.
No. Subsidiary under the
Central government.
In Indian Telephone
kindly comes to page 16. Page 16 at the top. Indian Telephone Industries Limited.
Page 16.
Annexure P1.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner was an employee of Indian Telephone Industries Limited, within bracket ITI, for short ITI, and retired on superannuation on 28 February 2023. Next paragraph. Learned advocate representing the petitioner submits that provident fund and gratuity were paid to the petitioner not on the were paid to the petitioner not on the date of not on the date of retirement, but same was paid, but same were paid belatedly. Stop. It is also submitted that leave encashment benefit is yet to be released in favor of the petitioner. Next paragraph. Prayer of the petitioner is twofold, comma, payment of leave encashment benefit and interest on delayed payment of gratuity, delayed payment of provident fund gratuity and leave encashment benefits. Next paragraph. You are representing Union of India or ITI?
No, only ITI. 2 to respond number 2 to 5.
ITI is represented by learned advocate, who is representing online.
Union of
Union
India.
of India. Respond number 1.
ITI and Union of India represented by learned advocates. Stop. Next paragraph. From the submissions made on behalf of the parties, it is indisputable that there was delay or there is delay in releasing provident fund and gratuity to the petitioner after his retirement on 28 February 2023, and leave encashment benefit is yet to be released. Stop. In view of delay in releasing aforesaid benefits, petitioner is entitled to get interest on delayed payment. Is entitled to get interest on those benefits which were paid not within time. Stop. Next paragraph. Concerned authority of ITI is directed to release leave encashment benefits by 2 weeks from the date of communication of this order.
My lord, my instruction was to seek for at least 8 weeks before your lordship of payment, my lord. Because the
And let it be forced.
আগেরটা কত সময় দিয়েছে? Very good. Directed by 8 weeks from the date of communication of this order. Stop. In addition thereto, concerned authorities of ITI are also directed to release or are also directed to pay interest at the rate of 6% per annum on provident fund, gratuity and leave encashment benefits from the date following the date of superannuation of the petitioner till the date of payments within a period of 3 months from the date of communication of this order. Next paragraph. In default of releasing interest in terms of the aforesaid direction within the stipulated time, respondent authorities shall be liable to pay 10% interest on deferred 10% interest on the amounts 10% interest on the 10% interest on the benefits which were paid belatedly. Next paragraph. Writ petition stands disposed of. Urgent Xerox certificate copy.
And one humble request, my lord, item number 249 of the monthly list. Another employee, same matter, my learned friend is also appearing. Can we not? Same matter, same prayer.
No, out of turn, I do not
But
entertain.
he is only appearing, my lord, and that's why.
There are several similar matters, Mr. Bhattacharya.
That's why.
Wait for some.
It can be disposed of.
It
my
is
lord,
an
by-
interest matter when people are not getting
Definitely,
pension.
definitely.
Every day matters are being mentioned.
Definitely.
Lordship kindly records my appearance, your lordship.
Yes, yes.
Item number 12.
My lord,
Yes.
my lord, in this matter, I'm led by Mr. Ujjwal Rai. He's on his legs before court 11, my lord.
Not today.
My lord.
Come back tomorrow.
No, my lord, I was proposing, as and when he joins, my lord, may I start?
Before
During
I
the-
start, some instruction is necessary, my lord. Can you give some date that
They are appearing for
Railway Authority?
Railway Authority. We will come back. Let him take instruction.
My lord, can I make one submission, my lord? The submission is that here the petitioner was wanting constitution of a medical board to reassess his medical condition to so that an opinion can be reached whether he is fit for joining duty or not. During pendency,
Really, it was filed on 26 November. Come back. He is seeking time to obtain instruction. Issue. File your affidavit of service.
my lord,
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Learned advocate representing Eastern Railway.
Southeastern Railway.
Southeastern Railways has prayed for accommodation to obtain instructions. Stop. List the matter under the same heading for further consideration on
January, my lord. Holiday, my lord. Second week January.
on 18th December 2025. Next.
grateful, man.
18th
My lord,
December. I have some problem, my lord. Kindly take it
Sorry,
first one.
sorry.
Can I take it up 21st?
Your junior will be there. He will assist. You take instruction.
Grateful, man.
Yes.
Item number 13.
Lordships before the petitioners before lordships are ex-army men below the rank of Havildar.
Just a minute. He is wanted to-
Court fees paid.
Yes.
Now they are the ex-servicemen who are below the rank of Havildar and not equivalent to below the rank of Havildar. They are the first strata who are sent. My lord. Now, after their retirement, they have a service of 15 years. After their retirement, they enroll themselves in Shoinik boards. There are several Shoinik boards. As opposed to in civil, there will be employment exchange. In respect of army, there will be Shoinik boards. Rajya Shoinik board is there, and there are Jela Shoinik boards. They enroll themselves that we are now unemployed, kindly consider us. Now, my lord, requisitions for employment, for appointments are sent to these Shoinik boards, and the Shoinik boards forward the names. Now, my lord, this requisition at page 20 was sent by the State Bank of India. May I just please?
Page 20.
Page 20. In this connection, this is being sent to the Rajya Shoinik Board by the Department of Shoinik Welfare. In this connection, we would like to inform that there are 28 vacancies remaining unfilled in the EWS, economically weaker section category of the said recruitment. Therefore, we would request you to forward the names of at least 560 ex-servicemen, 28 into 20 of the younger age profile, and preferably from fighting arms who meet the following eligibility criteria as to enable us to select most suitable candidates for the purpose. Candidates should possess EW certificates for financial year 2023-2024. And thereafter, the criteria are there. Upper age limit is 45, educational criteria, defense service 15 years.
Then if it is upper age limit 45, how it is possible? So far the petitioners are concerned because they retired at the age of 50.
No. They go in 15 years after, prior to attending 45, they retire. Say for instance, a person goes in a service in the age of 20. After
35 years.
Yes, he will retire.
15 years maximum.
15 years maximum. Now, my lord, after this, we participated in the process. The, my lord, EWS certificates are page 22 to 60, and page 61 is one of the sample copies where we were called. We have participated in the process. We have participated in the, my lord, physical fitness test held on December 2024. Where we had participated, and thereafter, since there was no reply from the bank, we had one of the persons had made a application under the Right to Information Act, and pursuant to that, page 97, they have replied. Kindly comes to page 97. Query number 1 and 4. Query number 1 is the current status of the recruitment process of the post. 4 is, if not probable date, whether the result has been declared. If declared, what is my position? Page 97 is the answer. The publication of result of bank guard recruitment process is withheld due to pending court case. Result is not declared in the matter.
Petitioners are within these 560 candidates. Those were requisitioned.
Yes, 560 candidates. Now, my lord, on the last occasion, one order was handed up. My lord, kindly see, this is the order which they are referring. They had not referred to this order in the, my lord, in their reply, but on the last occasion, my lord, the learned advocate had graciously appeared and said that this is the order. May I just place
This is the writ petition which has been referred to in page 97.
Yes.
Now, the pendency of a case.
Yes. Pendency.
Due to
Page 2.
pending court case. Yes.
Page 2 is, may I place the entire thing or the last part only?
No, entire
thing. May I just place it? Petitioners are directed to pay deficit. Petitioners are ex-servicemen. The petitioners have applied for selection process conducted by the State Bank of India for appointment of bank guards from ex-servicemen. The petitioners say that in the recruitment notice dated such and such 29 vacancies or horizontal reservation economically weaker section, the issue raised by the petitioner is as to whether the vacancies earmarked for being filled up by EWS category is to be filled up in the same selection process from the general category if suitable number of candidates under EWS category is not available. The petitioners say that the selection process is ongoing. However, the recruiting authority are in the process of carrying on unfilled vacancies under the EWS category for the subsequent recruitment.
EW is economically weaker section.
Economically weaker section.
Category only.
This fact is, however, disputed by the respondent. After hearing the parties and considering the materials and record, it appears that the matter requires to be heard on affidavits. Let the affidavit in opposition be filed. Parties will be at liberty to mention for inclusion in the list under hearing. On completion, it is made clear that any de-reservation or carrying forward of unfilled vacancy earmarked to be filled by the EWS category shall be made after obtaining leave of this court.
Here petitioners are under the EWS category.
It appears so. They have claimed.
Now in this writ petition.
My writ petition. Yes, I have annexed all the certificates.
But it is recorded that the fact is, however, disputed by the respondent.
Yes, fact is disputed.
And therefore the issue is pending as it appears.
But point is that it is made clear that any de-reservation or carrying forward of unfilled vacancies to be filled
It is
up.
made clear that any de-reservation or carrying forward of unfilled vacancies
shall be made. So therefore, if everything is filled up,
EWD vacancies reserved for EWS category candidates cannot be de-reserved, or such unfilled vacancies cannot be carried forward.
Unfilled. So if it is
Yes.
filled, then everything
Filled. If it is filled.
This is like in judicial recruitment. There is a 2002 rule which prohibits carrying forward. Here there is nothing.
No, are you relying upon this last paragraph?
No, I am saying that this doesn't, my lord, restrict the bank from carrying on with the recruitment process. And the recruitment process may be carried on subject to result of this writ petition.
What is the stand of the bank authority?
Well, this circular 12 June 2024 is the subject matter of the particular writ, my lord. Therefore,
Hey, Shono, just a minute.
yeah, the present writ petition. It is 12 June 2024. Most important is the number per 261. Per 261. This circular wrongly 12 June. They wrote 12 January, but the number per circular is 261. That is challenged in this writ petition, my lord.
I have not challenged.
12 June 24. 12 June 24 is the actual. No, they are not challenged. The other side, they are not challenged. In the earlier rate, this circular was challenged. And this is the writ, my lord, this is the prayer. My lord, can look at the prayers.
Copy.
This writ was filed there. It is not a regular recruitment, my lord. 5 years, 3 years interval recruitment is done by asking the names of the recruitment. So this is the circular that was challenged. And in this court, the matter is pending.
Yes, but there is no interim order.
But that case is pending in this.
But my lord, since there, I
It can be
think
hard
I
together
think
here,
that-
my lord.
Lordship kindly sees, there was a prayer for interim order. Kindly sees. So this has not been stayed. So everything can be done subject to the result of this writ petition. Then, my lord, they cannot show pendency of a writ petition for eternity. Because we, the petitioners, yes, yes, no, 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 but can't, but they cannot ipso facto discontinue the recruitment process 2010 ta date. They cannot ipso facto discontinue or not proceed with the recruitment process in its entirety. We cannot say that we are panel candidate, kindly say for instance 20 posts has to be filled. If they stop after filling 5 posts, the 6th person cannot come and say that look, you have made the notification for 20, you also recruit me. There is vacancy. That they cannot do. But if the entire selection process is not proceeded with, then we have some kind of right to come and say that you cannot be silent on this. That is my humble submission. That is the arbitrariness. Because if there is a only why how will be prejudice? There are several candidates in this writ petition before a lordship who had already crossed 45. They will not get any further opportunity of recruitment. No, it is not. They have already initiated completion, but there is no interim order. There is no interim order, and the honorable court has on the last, my lord, paragraph made it clear that if there is only unfilled vacancies, then only this point will come up. If all the vacancies are filled up, then no question of carrying forward will come. It is made clear that deed is no. Then my lord, they have to, my lord, withdraw the notification, entire exercise. Say for instance, it is dismissed. It is dismissed. So we cannot wait for eternity recruitment. But my lord, if that is, I understand, but kindly also sees, kindly considers this not in respect of this recruitment. Recruitment is recruitment, selection is selection. Now the SSC selection is going on. There are several writ petitions pending on several aspects. I am doing certain writ petitions. So can the board say or the recruiting authority say that there is a pendency of the writ petition, so therefore we will not proceed? That will be arbitrary. Because unsuccessful candidates will always come up in a writ petitions. Say for instance, there is no deduction. Previously also there was no deduction. 2016 selection process, all other selection process, big selection process. Here the bank is a very small person conducting selection in respect of 28 candidates. So therefore there is one writ petition. They are very, my lord, apprehensive of that one writ petition. Yes.
We have my lord, originally, we went for the recruitment of the guard. West Bengal, 294 posts are vacant. Then, my lord, EWC candidate was 29, reserved for 29 candidates. SC, ST, OBC. The general candidate, 100 to 104. Now, my lord, EWC candidate, only one candidate could be found. Then, my lord, we went to the circulars, government circulars. There said, I bought the circular. SC, ST, OBC backlog can be carried forward for the next year. But EWC candidate, they said you have to start a recruitment process for the same financial for that year. So 28 is left. For 28 selection, went there. For 28 again selections. There, my lord, then they went to the court that this should go to the general quota if it is not there. That is the main issue. One candidate was found. After that, 28 candidates, there was no available candidate was not there. Total 290. I have a list, my lord. About the APD opposition which filed, I can file the list. My lord wants to see, I can see it. So 294 candidates are necessary in West Bengal. Out of which jail candidate was 102. One second, my lord. I mean exact figure. No, 20. That could not be filled up because the candidates were not available in the recruitment process, and that is why, sir.
EW, sorry.
So under the circular went for further again recruitment from the EW only. The government circular says. Yes. No, we invited. Yes. So 28 vacancies, we have 28 vacancies under the government circular. For the 28 vacancy fill up, we have to exercise the same year process. We started the process. Then they're saying, no, they are not entitled to recruit them. It should go to the general quota because they have completed 15 years service after the cut-off date. 15 years service, they are not all the time before that cut-off date. So all the issues are there. Now they're coming with a plea that they are not completed 15 years within that recruitment year. So there we proceeded, we're ready. That is on how the court will interpret that. Because no, that issue will order, my order. One thing, my lord, one thing. No, court, this is it would not be carried forward. One thing is that, my lord, it is made clear the reservation is not there. Or carrying forward the unfilled vacancies. 28 was the unfilled vacancies. They have applied. No, but in your reply to RTI, you have not said so. This matter. This court case. The only point which was canvassed in your letter dated 4th November 2025 because in the petition there is an that is my lord, in the reply they said for the branch, but actual record says my lord, the record saying that the earlier read case record. No, I'm coming to that. Unfilled. Please try to understand that you have recruitment process on. Yes. Now his recruitment process was not brought to logical conclusion. Now the reason which is shown is of another. Now in the order passed by the coordinate wage at the admission stage at the please to extend the agreements with the condition that it is not carried forward without a due offer. Now it does not operate as bar in initiating the proceedings in conflict. The only thing is that there is no such bar. But while doing so, if you find that some of the candidates are ineligible, declare them ineligible. The one thing is that the state has not now case to case basis consider whether what are those candidates who are eligible or not. That is to be exercised by the bank authority. If it is Well, one thing is that
But since it is taken, it is implied tendency of the litigation. In the litigation, it is shown that the litigation, there is no restraint order, only two conditions are there. No reservation, no carry forward of it.
that
So therefore, complaint is condition. Where is the difficulty in proceeding with the selection process in terms of the litigation?
well, one thing is not clear. I'm finally saying, my lord, not clear to the bank, my lord, that filled up by the EDS category, earmarked to be filled up by the EWS category.
The stage has not reached, court will not act as a medical care, medical staff to find out whether one candidate is eligible and the other candidate. That exercise has to be carried out by the bank authority.
Recruiting person.
Where is the bar in the pendency of the litigation? There is no restraint order by the court. Why you are raising this issue at this stage?
Only apprehending.
Show me that where is the difficulty so far bank is concerned. You proceed with the selection process. Because in the order there is no restraint order, rightly put it out by Mr. Lai.
Restraint order is not there. But only thing,
Not to proceed with the selection process pursuant to notification with the recruitment.
no, then we had to, whether we had to go.
You are now trying to tag out several other things in order to.
Not frustrated. We are ready. We everything is ready, my lord. But only thing is that
Do this, court will permit you to do. In view of the order passed by this court, you conclude the proceedings. While doing this, if you find that some of the candidates are ineligible, declare them eligible, don't participate.
they have participated. Selection result is also ready. Only thing is that leave of the court is to be taken. This court will pass the order to be taken before.
Everything is complete. Only the result.
Yes. Only apprehending later on that case is pending. Something turns out that everything is wrong.
That this selection process shall be subject to legal
That is, everyone will know. This is the whole thing, my lord, directs that it should result, any selection result will be subject to result of the court's order, as a subject to result of the query. Then
I was under the illusion that most
everything is yes, the physical test only that was done.
Carrying forward
Carrying forward, my lord, that is the issue. Carrying forward is there, my lord, already. Because that should be
subject to the result.
28 vacancies unfilled. The 28 unfilled. We are doing the exercise for 28 vacancies. 29 was the original vacancies for the EWS. One candidate could do good found. 28 was unfilled vacancy. For that, we are doing this exercise. 29 was the EWC candidate.
No, in connection with black, there are 20 vacancies.
20 vacancies because 29 vacancies original was there. One is taken. All the process.
No, this is the selection process of
21, 24, 21, 20, 21.
in connection with 2024 selection process, there are 20.
No. All original. The vacancy is for 2021 financial year. There, 28 vacancy was 29 vacancy was there for the EWS. We could find only one person. 28 vacancy was there. Then there is a government. That person was appointed. That person was appointed after selection. 23, 24.
So therefore, why you are saying
29 vacancy was originally there.
no, this is the selection process of
21, 22, 2021. That is 21, 22. This is selection procedure we're doing. 21, my lord, 2021 is a selection recruitment year. My lord, may I come to the Here there is a notifications that you cannot carry forward. EWS could SC, ST, OBC I can carry forward.
পিটিশনটাও জেরক্স করে নাও।
Earlier, 21, 22. Well, chart is there, man. We are doing in 24, but these vacancies are of that year. 2021 financial year. Financial year. That is why Ballard will kindly look into that. No, court, government notification says that even a particular financial recruitment year, EW candidates, SC, ST candidate are there, not could be filled up, it should be taken as a backlog to the next year, next recruitment. But in case of EWS, you have to again put the exercise. That's what is here, madam. So we put the second exercise. SC, ST, OBC, these if not can be if it could not be filled up, it should be carried forward for the next recruitment process. But in case of EWS candidate, it cannot be carried forward. Face exercise should be done. State selection.
This is the face.
The circular here, madam. I'm showing the circular.
So is it your contention
That selection I started.
the selection process of 2021? 2021. So therefore, there were vacancies of
'Well, chart, my lord. Kindly look at the everything will clear, man. This is a chart I've given, my lord. I'm showing it. There is 20. Therefore, we page 15, page 20. Page 20 of
এটারই পেজ 20 চাইছি।
page 20.
হ্যাঁ, এটারই পেজ 20। জান আর 13 দেখছি।
That's the same process which have already done along with the other general candidate.
জান আরেকটা জান এই যে
in connection with which selection process? Which selection?
Recruitment year 2021.
Where you have taken?
That has somewhat which was stated, my lord. Kindly page 1, kindly look into page number 20. That is the vacancy that time. Page 20 of my affidavit. In that case, West Bengal, undeserved 120.
That I have seen.
Huh.
That under EWS there are 29 vacancies, one was selected, 28 remaining. Where you have stated that the selection process connection with 21.
Because of that advertisement, of the repetition advertisement.
Which advertisement?
For that year. That is in the read.
The candidate should possess EWS certificate for the financial year.
No, the advertisement of that year. The read petition is here, my lord. They've been closed. That read, not this read.
It is also 2024.
This 22, 2020.
In the read petition.
In my read petition.
Not notification of where January 2024 was the change, not the previous selection.
24.
Yes.
Yeah, this is the advertisement. Yes, they've challenged this. But that emanates from where? That emanates from here, my lord.
So who is not saying that
This is not individual. This is not.
Under EWS should be or needs to be carried forward for 2025 selection.
No.
Court is restricting the exercise in connection with 2024 selection process in respect of 28 EWS
No.
EWS vacancy.
2024 amendments from where? Because of this, my writ, this is my writ petition. I have already given writ petition. Earlier writ petition, their writ petition. My lord can look into. This is the writ petition. One second. It after it. I have given the writ petition, my lord. There, my lord, page 23. That is that 22. We have invited the.
Court was considering that relating to 24 in respect of 2024 based on 2023 based on January 2024.
This is a.
Now, court said there will be no further carry forward of
No.
EWS vacancy.
Wherefore?
Court is not saying that you carry forward EWS vacancy to the next financial year 2025. You restrict your exercise in collection in 2024.
Malab, original vacancy.
That is not the purpose.
That is Malab, page number 23. Page number 23 is the first advertisement, Malab. First request. That is page. This recruitment is done because of the government gazette notification.
So therefore, what directed no further carrying forward. So therefore,
It is carrying forward.
You are this post in connection with 2024 selection subject to result.
That is why. Well, one thing is that okay, I have no problem. But only thing is that
Petitioners are economically petitioners are beyond economically weaker within the participate in the selection process for filling up the vacancies of bank cards at several branches. Stop. Petitioners are exercising. Stop. Next. Mr. Lahiri Senior submits that a notification was issued in number R/261 for recruiting for filling up vacancies at several branches of the in West Bengal. In terms of state recruitment competition, petitioners participated in the selection. But the demands of the petitioners state recruitment process based on notification is not brought to light. So, petitioner based on selection upon the concerned application of upon the concerned network for concluding the selection and hearing with the conditions as stipulated
in the order dated 1st October 2020, Next paragraph, piece of this code has two. And later, issued by chief bracket and this in response to an article and in response to article very it was informed. Now whereby it was informed that due to agency of litigation steps to not be taken in terms of litigation. Next paragraph. State Bank of India is who has placed now who submits all of it all steps were taken pursuant to recruitment but result is not published.
And the interim order.
And the all by the coordinator. It is also published that carrying forward of vacancies result for EW is candidate is impermissible. Therefore, the vacancies arose that EW is candidate in the previous year. May not be filled in connection with the recruitment process of the case was initially pursued recruitment notification
Because of court order, madam, my submission. My submission to the record, madam, because of the interim order of the court. My submission had recorded.
That is ordered by the court dated first.
That I have heard, madam.
Next slide. Taking note of the submissions made on and the letter dated and letter issued on behalf of in response to primary capital WPA 1751 and the order by the court is on result of the selection copy of the restitution with WPA 1751
and on perusal of the same, that challenge is not to the regular notification date.
Let me 12 June, madam. No.
Yes. By this the like to convert
That it. That is why this order was put. Yes.
convert unreserved. That is not your
No.
because the petitioners are
Yes, it is.
That is their case. They want. If it is vacant, they will get the appointment. They are waiting in the line. If it is converted.
and to convert and further to convert the and further to reclassify will be vacancy reserved for PW case candidates and general as vacancies under general. So, order passed by the coordinated bench dated 1st October 2024 is taken on record. Therefrom, it appears that there was no restraint order so far bank authorities concerned from giving effect to the recruitment notification with the rider that the reservation of post or carrying forward of unfit earmarked to be filled up by PW's candidate shall be made after obtaining new order. In the present case, petitioners are not paying for carrying forward of vacancies petitioners are not paying for carrying forward of unfilled vacancies reserved for PW is candidate. And no prayer is made for reserving those. Stop. Both the restrictions, present restriction and the restriction 17514 relate to recruitment process of recruitment process of
That's it. It's for recruitment 21, 22. First list. Recruitment was of 21, 22.
2023, 24. And recruitment notification was issued on 12th June. Next, hence, court finds there is no factor in arguing the bank authorities bring the selection process initiated terms of recruitment notification on compliance of two conditions as stipulated in the order.
But that will be a difficult problem. The kind did not put the bank.
According to concerns statement are related to publish the result of the are related to conclude the recruitment process initiated in terms of subject to final result. But while taking steps, there shall not be. But while taking steps, there shall not be. But while taking steps, posts are not to be visible, and vacancies are not to be carried forward for the next selection process. That is from 23, 25, 2024. In connection with the category. Next. Next, with the aforesaid clarification,
The result, they will be
Appointed.
Their appointment is subject to the result of the.
বলে দিয়েছে
Then finally, my copy of the writ and my affidavit filed in the earlier writ can be taken on record, my lord.
I have taken on record the order, only for putting and correcting my order, your resolution.
Retribution and my affidavit.
You will get back your copy of the resolution. But the order of the coordinate dates.
That is. Well, I don't know. Again, further litigation will come. Because other day the lady was present, other side. He wanted to, he had given the copy to you.
Deeply.
Best ballot thing was that both the cases were heard with this court ballot. In this court, both are pending. Could be disposed of.
Chalo. Deep look.
Item number 14.
For the petitioner.
I'm for Union of India.
Yes, we for the petitioner.
I am for the petitioner. The petitioner, Mrs. Orpida Sengupta, was appointed as a data entry operator under the management of Executive Engineer, Kolkata Central Electrical Division 1, CPWD, Nizam Palace, Kolkata, and through the contractor firm, that is Messrs. Shivorti Maintenance, 197/11 Rastaguru Avenue, Kolkata 28, my dear. And our service were terminated with effect from 31st of May 2023 without giving any notice pay, retrenchment compensation, etc. with the plea that she had attended the meeting of the union. That is the charge, my lord.
Meeting of the union held on 27th of April 2022. My lord, which is clear-cut violation of section 25 G and H of Industrial Disputes Act 1947. So, my lord, that the petitioner made a representation, my lord. Yes, my lord. My lord, it relates to service, my lord. My lord, actually, I want the matter be reheard. My lord. What is the order of the impugned order? Impugned order is, my lord, at page 41. 40 is the forwarding letter and 41 is the order, my lord.
Page 37 is a handwritten order. My lord, order sheet is page 36 onwards. 2 days he missed. So cause issued. It should be classified as under classification not as and he reclassified the as lost.
অ্যামেন্ডমেন্টটা করে নেব।
Item number 15.
Item number 15, my lord, I have for the petition, my lord. Before your lordship, my lord, sirs, there are two things. My lord, firstly, it is a post which I am praying for an appointment in a civil post, but since my lord, tribunal is not functioning, I approach your honorable. My lord, tribunal is not functioning. Yes, my lord, the law is settled by the division bench as well as by this. My lord, tribunal.
You need to find
My lord, with deepest of respect, this has been settled by our division bench, my lord, as well as by the Supreme Court in. My lord, the Honorable Supreme Court in 2026 SCC has clearly stated that in such situation, the High Court will have the original jurisdictional court will have the jurisdiction to hear, and our division bench following that has passed this order, my lord. Kindly see. Our division bench, my lord. Please, Supreme.
আপনি কার হয়ে আছেন? আমি স্টেটের হয়ে। পিএসসির লোক কোথায়? পিএসসি তো লাগবেই। উইদাউট পিএসসি হবে না ম্যাটার।
No, my lord. No, nobody is there. My lord, with deepest of respect.
Yes, yes.
My lord. My lord,
Yes.
presently, my lord, only one. Presently, there are no
It's all right.
administrative member, no judicial member.
But filing is going on there. Filing is going on there before the register is there. Everybody is filing there.
My lord, presently.
Yes, yes.
My lord,
It is
kindly
not
see
non-function.
390. My lord, 392 of the Supreme Court. My lord, it's a constitution bench judgment. My lord, 392.
Lordship.
My lord, another thing, my lord,
Apart from
I said, my lord, this is against PSC, my lord, because of my mistake, my lord, PSC has not been served. I will also serve the PSC. In the meantime, I will also send a notice to the Advocate General to the respondents has been wrong. Petition number 2, I will serve. Respondent number 2, I will serve.
PSC is the answering respondent because of recruitment proceedings.
I ought to have checked it, my lord.
I am for the state respondents, Lordship, from the release orphan. My lord,
my lord, your lordship can. My lord, he has retired.
He has retired. Yes,
no one, my lord. I said
only the register is there. So far as my lord, I in the yes, I know. But filing is going on there. Yes. Whether he has to file over there and come with that.
Roger Matthews, my lord, the constitutional bench has clearly held that in such cases it will be 226. There will be no alternative.
Yes, yes.
My lord, jurisdictional.
Before the division bench, as it has been held in L. Chandrakumar.
Yes.
My lord, L. Chandrakumar has been considered here, my lord. Kindly see.
Then WP
My lord, I cannot approach the division bench directly.
Yes.
If the tribe, there is no judge in the tribunal. If there is a single member, I ought to have approached this. My lord, filing is permitted, but
We used to do regularly.
Yes.
Well, it was mentioned, it was not heard.
my lord,
Thereafter, they are coming to this
these very points.
in WPST.
My lord, this very point has been dealt with in paragraph 392 by the Constitution bench, that there cannot be an efficacy or alternate remedy. The litigant should approach the jurisdictional court under only for once, my lord.
That is also 226.
My lord, kindly see, it is clear, my lord, 392 once, my lord, of the Constitution. Paragraph 392.
দেখি এখান থেকে ওরাও তো 226 এই ফাইল হচ্ছে WPST যেটা ফাইল হচ্ছে
Jurisdiction court. My lord, page 1.
You had read about 94.
392, my lord. Here, my lord, there is no.
But there is no member at present.
My lord, that is.
See the language. It says that therefore, I don't know. That whichever state or
established.
My lord.
Of the state will have a right of extraordinary
Yes, my lord.
Yes, they cannot be expected to are of different places and spend huge amounts of money much beyond their means to pay. What has been
My lord, T.N. Chandra Kumar said, my lord, it's from tribunal.
No.
Not before the division means what, my lord? What it is? No, before the division means what, my lord? Where he said?
No. Yes.
It says where the bench is not established or not functional. Here the bench is not functional.
The division bench is the WPST.
Bench. It says if the bench is not functional, my lord. How is? My lord, it is saying established or functional.
Yes.
The hearing is not
Taken out.
That I always have.
matter is not there because the indicates for any reasons that we have to file a petition as directly under
This.
My lord, that I
Yes.
always
Yes.
my lord. That
Yes.
if I file a case before the tribunal, my lord, I can always approach the High Court under before the division. My lord, if I file a original application before the tribunal, tribunal may be functioning, my case may not be taken up, the bench may not sit, I can always approach the division bench under Article 226. For my that is L. Chandra Kumar is clear. My that 390 226 division means what, my lord? Paragraph 392, my lord, with deepest of respect, it says if the bench is not established or non-functional bench. Here, my lord, the bench is non-functional. My lord, kindly see, my lord, with deepest of respect, my lord, kindly see bench is not established or non-functional.
it is not said bench. It is said observe that I want to believe that in whichever state or union area the bench or the bench on particular tribunal is not functioning.
Yes, that is my case. It is not functioning. There is no judicial member or, my lord, administrative member. This is my case. It is not functioning. The bench is not functioning. Earlier, my lord, only an administrative member was there. But now, my lord, the present scenario, there is nobody. And my lord, mere futile, if the alternative remedy is not efficacious, my lord, your lordships can always take up the matter, my lord.
This is
My lord, in Chandra,
Window relating to Article 26 before the High Court, but that will be before the division.
and that means I have to approach the tribunal. If the bench is not functional, my lord, the alternative remedy is a futile formality, my lord. And furthermore, my lord, our division bench has also opined that specifically that it should be single bench group C.
I have a but if you lost the hearing for 1 week, there is another point for us that we can. Restitution is filed before on the people that West Bengal Administrative Tribunal is West Bengal Administrative Tribunal and the benches under the same tribunal are not. When benches, when bench under under West Bengal Administrative Tribunal is not valid. Litigant is required to approach single bench, not single bench of the High Court under Article 226 instead of approaching the Is present. Before this. Next one. Pattern as well. 392.
390. On a 2020 volume 6 SCC page 1. Page 242.
Reliance is based on paragraph 390. The aspect of problems. Of 5 such range of options. Before we get 20, volume 6 cases 1. With this bracket, Roger Matthew versus South Indian. And also Egyptian claim classification. Reliance is also passed by honorable Commission of this court on the resolution in the now, TSP. Alternatively, canvas with the resolution or
Lordship.
This is the matter under the second.
My lord, I think also subject respondent number 2, my lord, Public Service Commission in the meantime.
No, I will public.
Yes.
No, I have to.
It goes with
I
FC. It goes with FC. Eda. Eda, Mr. Husho, virtual yes. My lord, in this matter, I am led by Mr. Bushu. He is on virtual. Yes.
No, I am in the pairing on the stand virtual minutes.
My lord, only one thing since Monday is
Mr. Boisho,
Lordship.
I have requested Learned Advocate General to appear in this matter. To assist.
Lordship.
Yes.
Lordship.
only one thing since Monday, your lordship by 15th I will serve. My lord, can I get the server copy by?
Generally, in my court, on the next day, server copies are available. Very well, I am extending one more day.
They need to be 16th.
Yes, just a minute. Yes. By 17 December, করে দিন তো service টা.
Lordship, I am grateful.
So that I can get one opportunity.
No. Next matter. Yes. Don't canvass any points at me. Yes, next.
Item number 16.
You could not effect service of notice upon other respondents, upon the respondents. You are appearing for the petitioner.
Very small matter, 120 days of
How I can, unless until service is not effected, you have lost the brief. Issue. Learned advocate representing the petitioner prays for leave to apply for certified copy of the writ petition, as he has lost the copy of the writ petition. Stop. Let the next paragraph. Let the writ petition be brought down. Be sent down to the department. Be sent down to the department immediately. For providing certified copy of the writ petition to the learned advocate representing the petitioner on compliance of necessary formalities. Stop. List the matter under the same heading for further consideration. On 19 January 2026.
16 to 20.
Huh? All matters you have lost.
Yes, because in the back it was.
Oh. In all matters you have lost the brief. How it is possible?
Yes, lost somehow. Somehow. I'm very humble. I have also 9 matters on Monday.
There also you have lost the brief.
For certain God, we have.
So therefore you are champion in losing brief.
No, it will know now on 15th and 5th, 9 matters are ready. Only these 5 matters are.
Call one after another.
17.
Same order করে দিন করে দাও
18.
Next. Same order
19.
same order
20.
other side এর প্রশ্ন নেই ঠিক আছে yes 20 same order
Item number 21.
For the respondent, my lord.
affidavit service
The worker in this matter and it should have been appeared in under the 3.
group 3 matter yes learned advocate representing the petitioner submits that the issue involved in the writ petition relates to group 3 of classification list of different types of writ proceedings. Stop. Leave is stop. Next paragraph. Hence, writ petition stands released due to want of determination and be placed before the appropriate bench. Next paragraph. Leave is granted to the learned advocate representing the petitioner to amend the presentation form and pro forma page of the writ petition to reclassify the writ petition as group 3 matter. Give your append.
Item number 22.
Sir, I am of the petitioner 22 and 23. My lord, I beg you, Lord, kindly allow me to rectify the address of one respondent, Union of India. Topographically, I have made mistake. Union of India, Ministry of.
But state is also party. Have you served notice upon the state?
My lord, all I have served, but the Union of India I could not serve. My lord, kindly allow me to be. I'll rectify that and serve.
Branch Secretariat, Ministry of Land Justice is to be served, but they are not to be added as a party.
No, my lord.
Appropriate ministry is to be added as a party.
My lord.
So you want amendment
For respondent number.
amendment against respondent number 4.
My lord.
Issue. Learned advocate representing the petitioner prays for leave to amend the cost title of the writ petition to describe the respondent against, to describe the authority against respondent number 4, to describe the authority against respondent number 4 appropriately. Stop. Stop. Next paragraph. Leave is granted to amend the cause title of the writ petition to describe the authority against respondent number 4 appropriately by tomorrow, 12 December 2025. Stop. After such amendment is carried out, learned advocate for the petitioner is directed to serve notice upon all the respondents by 10 days thereafter and file affidavit of service on the next date. List the matter under the same heading for further consideration on 13 January 2025. 2026.
Item number 23.
Yes, item number 23. At the time of call, no one appears for the petitioner and no accommodation is paid.
22, 23. And the similar.
Same order করে দাও।
Item number 24.
Lordship, I beg to appear for the petitioner, Your Lordship.
Lordship, I beg to appear on behalf of the respondents.
Lordship, service has been affected. If my learned friend wants to use the affidavit, then Your Lordship would pass this.
Yes.
If my learned friend wants to use the affidavit, then the Lordship would pass this direction.
No, that depends upon the order to be passed by this court. Why you are praying that there is a direction for affidavit? Place your order. Place your case.
Your Lordship, this is
And
my
court will examine whether at all a filing of affidavit is necessary or not.
Lordship, this is Lordship, the petitioner here is the wife. Lordship, the husband of the petitioner was employed before the Eastern Railway, Your Lordship. Now, Your Lordship, he has been the petitioner here. Lordship is 83 years aged, Your Lordship. Now, this is a claim
who's
the
age?
petitioner. The petitioner. Petitioner is the
Her husband was employee of.
her husband was employed.
What petitioner is claiming?
Family pension, Your Lordship. Because
So how this writ petition is maintainable? You have to approach the Central Administrative Tribunal, Kolkata bench.
Lordship. Now, in that regard, Your Lordship, there has been multiple communications made, multiple letters made. They have been.
If your husband was an employee of Eastern Railway,
yes, Your
in that event, you need to for getting pension or other service related benefits in connection with service of your husband, you need to approach Central Administrative Tribunal. It is at this stage writ petition is not maintainable before this court.
Lordship, there are circumstances and situations when the writ court can exercise jurisdiction,
No.
Your Lordship. Lordship, kindly allow me. Kindly bear me, Lordship.
That is not the idea of forming tribunal. Have you gone through section
14? I've seen, Your Lordship.
14
I've seen, Your
of
Lordship.
the Tribunal Act 1985?
Administrative Tribunal Act.
So
Yes,
then,
Your Lordship. Yes, Your Lordship. But perhaps here there has been no communication from their end. How do I go to anywhere? Because they have not replied to any of my letters.
but
They have once
but at
told
the
me.
end of the day, Mr. Advocate, you are seeking a direction upon the railway authority in connection with service of your husband who was an employee of Eastern Railway. Esho.
Lordship would kind.
Husband of the petitioner was employee of Eastern Railway. and prayer is made in this writ petition for certain benefits in connection with service of her, petitioner's husband. Stop. Since petitioner's husband was employee of Eastern Railway, writ petition at this stage is not maintainable before the High Court. Stop. Hence, writ petition stands dismissed. However, this order shall not preclude the petitioner to approach Central Administrative Tribunal on the self-same cause of action.
Your Lordship would
That
kindly,
is to act on the server copy.
Your Lordship would kindly grant me the liberty to file afresh if required, Your Lordship.
Yes, I have granted liberty to approach the tribunal on the same issue.
Your Lordship, I shall have the right to file after if I don't get the order there. Your Lordship.
Yes,
Your Lordship would kindly grant me the liberty to come in appeal if I don't get the order there.
that liberty is not required. That liberty is inherent.
Grateful, Your Lordship. Your Lordship, 83 years age, Your Lordship. Now, before the tribunal comes up
But
with any
you are
kind
there
of
to
solution.
you are there to advise your
Lordship, with
client.
respect to that, in our representation itself, we have indicated which department to approach for the family pension. In our reply as well, it is mentioned in their writ petition.
And thereafter,
How
we
it
have,
is
How is
maintainable,
it?
it is not
thereafter we
maintainable.
have still wrote to them, but
Please call
no
the next
reply has
matter.
been given by them.
Lordship, all the replies have been given. It's a part of the writ petition.
It is not there.
Reserve your energy and appear before the tribunal.
Grateful.
Item number 25.
I am for the respondent.
My lord, I'm very close.
Lord, the factual matrix of this particular matter is that one notification for recruitment of assistant professor PMR, physical medicine and rehabilitation, was notified on
Physical medicine
and rehabilitation.
rehabilitation.
Was notified on 10th of July 2024 by the respondent NILD.
Respondent?
NILD, National Institute
NI
of Locomotor Disability.
National Institute of Locomotor Disability.
By virtue of that, I applied for the role of assistant professor, PMR, and I was called for an interview, and the call letter was issued on 10th of April 2025, and I appeared for the interview on 24th of April 2025. And on 28th of April, the result for the interview was declared, and
For the post of
assistant professor, PMR.
assistant professor,
PMR, physical
PMR.
medicine and rehabilitation.
Physical medicine and rehabilitation.
Indeed, Your Honor. Then, what in that particular result, I was placed as waitlisted 1, rank 1, and there was another candidate who was selected candidate. So, the candidate was in terms of the DOPT.
Are you challenging the selection of another candidate?
No. I'm not challenging the selection of the another candidate, but I am challenging the whimsical giving of extension to the other candidate. Because
Now, if your writ petition is allowed, then extension which has been granted to other candidate will be terminated.
Indeed.
So then those candidates are required to be added as party
There is one
because they are the vitally affected party. What?
Your Lordship, because of the DOPT's notification, because of the DOPT's
Please answer the query of the court that if you have questioned the extension granted to another candidate, now if your writ petition is allowed, that candidate will lose his right to work during with the help of extension.
He's right.
Now he needs to be added as party. Why you have not added him party?
Indeed. Your Lordship, his right has already been lost because as per the office memorandum dated 9.
Whether extension was granted to another candidate.
Extension was granted in total. For a period of 6 months total from the date of making an offer.
Now, if your writ petition is allowed, in that event that extension goes?
By virtue of the DOPT's office memorandum dated 9/8.
If this writ petition is allowed, that extension will be termed as illegal.
Illegal, correct.
Then the benefits which percolated based on such extension will be diminished.
Indeed.
So therefore, that candidate needs to be added as party respondent.
Indeed.
So why you have not done this?
But I have not made him party because of a simple reason, Your Lordship, that by virtue of this notification, para 2 of this notification, office memorandum of the DOPT,
extra check.
9/8/1995. By virtue of this notification, from
Issue.
from the date of making offer, kindly.
How many persons have been given as extension, Mr. Bhattacharya?
My lord, we offered him appointment and he paid for extension, my lord.
But
That is the position at this stage, my lord. Although the extended period has over, but he has not replied anything till date.
He has not joined. So if he
You
fails,
offered appointment, fresh appointment.
This is a selection process was initiated. A panel was published. My learned friend's client was placed in the second position of the panel. The first member.
How many posts were there?
Only one post.
Only one.
Two candidates.
The first candidate declined.
No, decline not decline. That is the problem we are facing. So we offered him the appointment.
Why? Because there was another candidate above the petitioner. Here's the second
candidate. No, we have not offered my learned friend's client. We offered the first panel candidate. And he made a prayer for extension.
kindly allow me to make one submission in this regard. Your Lordship, kindly allow me to make one submission in this regard. Since the offer letter was given to the selected candidate and more than 6 months have passed, so as per this particular DOPT's notification,
Yes, Mr. Bhattacharya, what you were saying?
this offer has already.
I have not seen such a, just yesterday I received the brief. I have not seen such a notification, but what my lord has said that person first panel partner is required to be made party because we have given the offer letter. He made
Now, you are saying that offer was given to the petitioner being the second man in the panel.
No, first man.
Petitioner was the first candidate.
No.
So why offer was not granted to the first candidate?
First candidate. We offered the first candidate the appointment. He made a prayer for extension of time, my lord. That letter is with us. So this is the position. And thereafter, he did not report anything till date. So this is the present situation, my lord. So if he made the party, my lord, the matter can be settled once for all.
Resolved for once for all.
Once for all.
Your Lordship, by virtue of the DOPT's notification, his offer has already revoked automatically because since 6 months have passed, so I was supposed to be offered.
Sure.
If he fails to
Give particulars of the first panel candidate to the petitioner. I will grant him leave to amend the writ petition and add first panel candidate as party, and thereafter he is to be served. And
Your Lordship,
it is a post of professor,
assistant professor,
assistant professor,
PMR,
full form,
physical medicine rehabilitation.
physical medicine and rehabilitation. Physical medicine and rehabilitation. Where?
NID, National Institute of Locomotor Disability.
Rehab. Matter relates to
Kindly consider.
please wait. Matter relates to selection in the post of assistant professor, physical medicine and rehabilitation in National Institute of Locomotor Disability, Kolkata. Stop. After hearing the learned advocates representing the petitioner and Union of India, Union of India, it appears that petitioner was placed at the second position in the panel, and in spite of granting opportunity to the first panel candidate, he did not join the post. Stop. Next paragraph. In the event petitioner is adjudged to be a fit candidate for being appointed against the post of assistant professor, right of the first candidate will be withered away. Stop. Next paragraph. Hence, leave is granted to the petitioner, learned advocate for the petitioner to amend the cause title and add first candidate in the panel as additional respondent.
I am handing over the details of the
additional respondent by tomorrow, 12th December 2025. After amendment is carried out, learned advocate for the petitioner is directed to serve notice enclosing copy of the writ petition and the order passed today upon the additional respondent by 10 days thereafter, and file affidavit of service on the next date. Today you have filed affidavit of service. উপরে দিয়ে দেবে, service filed on where the petition is taken up. And file further affidavit of service on the next date. Next paragraph, details of particulars of first empanel candidate are supplied to the learned advocate representing the petitioner during course of hearing. Stop. Next paragraph, list the matter under the same heading for further consideration on January 7th, 2026.